the Master Netting class, hosted by Lamont A. Thomas, founder of the Supreme Elite Team University.
In today's session, we moved beyond theory and into application. We focused on how contract-related assets and liabilities are actually recognized, classified, and on corporate using the same accounting framework relied on by institutions like the class examined authoritative guidance on and contracts and how the timing of performance, invoicing, and unconditional rights to consideration determines whether a company records a contract or a contract. We walked through how entities recognize when the only remaining condition to payment is the and how contract assets arise when payment is still something that directly impacts recognition. From there, we connected that framework to accounting principles, showing how it confirms that contract are evaluated at the level, not transaction by transaction, and may be presented when the rights and obligations are. This is where the economic comes into focus. We analyzed how finance companies receive in advance, how securitization alter the position of the original, and how those interact with the borrowers when viewed through accounting. The class also addressed the distinction between how an account labeled as may already be structures using real-world auto finance examples, including structures. We showed how recognition and decisions appear in and how those disclosures matter when asserting administrative rights to and set off. This session wasn't about disputing debt. It was about determining who holds what amount remains after realization and how the obligation should be under established accounting standards. Part 3 sets the foundation for understanding why is not a loophole. It's an accounting reality that courts, regulators, and auditors already recognize. In the next phase, we build directly on this framework to show how these principles are asserted administratively and, when necessary, enforced.
Supreme Elite Team University. If you've watched this far, then you already know, not every voice online is rooted in truth. That's exactly why we created SETU, Supreme Elite Team University. Not just another class, not just recycled ideas. This is where consumers come to gain real clarity, real confidence, and real strategy. We don't chase followers, we build leaders. Enrollment opens February 2026. Spots are limited because we only work with those ready to take action. Don't get lost in hype. Get aligned with truth. SETU is coming, and this time you'll be ready.
I want to say one thing. There is very little people that I have utmost respect for, and I'm not saying this to brownie point or anything because it makes no difference to me. I'm that cut and dry. Lamont is only one of maybe a handful of people, 5 people, that I have the utmost respect for what comes out of his mouth. And you've got a great teacher.
You're rocking with the best. You're rocking with the best.
What's going on, YouTube world? Today we have a reaction video with another pro se litigant trying to go up against one of the credit card giants in Capital One. Things has been very busy lately. Ever since Miss Kenyatta Stone went live about me 3 times, I actually gained a client from her watching Miss Stone talk about me. Not only did I gain that new client, got 91 new subscribers in a few days, and 80% of them were from 91 subscribers in a few days, and 80% of them were from Facebook. So you tell lies about me, I'm going to tell the truth about you. Now, this was from an attorney who has background in securitization. This attorney has background in securitization. Yes. And what I was teaching her, what I revealed to her, she did not learn as being an attorney and having background in securitization. Now, it's not uncommon for professionals to reach out to me after already going to school and getting their certifications in these specific fields. It's actually not uncommon at all. Actually, it's been happening a lot frequently. So, once again, with these online gurus, you have to be very careful on who you put your trust in. Because one thing that's very evident is that I and what I teach and my methods have been stamped by the top professionals in this field. So anything that comes from me is the equivalent of you going to a top attorney. The extensive knowledge and understanding that I have of the system allows me to see things and attack things from which the average consumer wouldn't even know exists.
You're rocking with the best.
And that's not a slight. It's not a dig. It's not a brag. It's just the reality that in order for you to really make headways with these people, to really get them to take your documents and your filing seriously, you're going to have to know inside very very few people know type knowledge and understanding to attack your case in a legal professional manner that's not going to lead to immediate judgment against you, like what you see online. So the Supreme Elite Team University is taking all my studies and findings, mixed in with all the professionals and some of you don't know. Maybe you just may be studying from the same material and information and authority relied on by a top ex-SEC attorney. You just may be studying information and material and being taught from documents and papers from an ex-World Bank examiner, from an ex-FRB examiner, from an ex-top Deloitte executive officer. Maybe the material in this set university may be the same materials that they teach the top professionals in this field. Maybe.
You're rocking with the best.
So maybe after graduation, you will know how to attack your situation and your loved ones from a professional legal point. And I guarantee you, after the Supreme Elite Team University, after graduation, this will change the landscape on how consumers' rights, consumer challenges are going to be taught online. I will be setting the new standard. I will be setting the new standard because in 2026, the tidal wave is already here and the hammer is coming down. I know they want to skew the numbers and act like we're not in the middle of it. But 2026, you are going to realize that we have been in a recession since COVID. Repossession numbers are at the highest since 2008. Foreclosures at the highest since 2008. Access to credit is being tightened up by the day. The markets are panicking. The ratings agencies are not giving favorable ratings to these secondary market securities. Oh, all the evidence and all of it points towards a full-blown recession in 2026. Now, a recession only affects a certain class of individuals. If you're a millionaire, you're worth millions of dollars, a recession is only going to make you richer because you'll be able to buy things on pennies on the dollar and wait for the value to increase again, and then you can make huge profits. You'll be able to capitalize. But for the average day people like you and I, and for some people who doesn't have the financial means to just pay their way out of their obligations with their own cash, not talking about a fake check, at the end of the day, the only thing that you're going to have left, whether if you have money is tight, whether, things are tough, the one thing that you're going to have that is going to be even better than the money to pay is the understanding and the knowledge that the Supreme Elite University is going to bring that would allow you to legally get out the constraints of this financial system that it can have on people and the toll and the stress it takes on people, not because they lack sufficient funds. It's because they lack the understanding on how to attack it. Now, regardless, me and mine's going to be good regardless. Like I said, once you have it, no one can take it from you. So regardless, I literally could care less because I'm literally going to be doing the same things. I'm literally going to be filing professional like documents. I'm literally going to be filing lawsuits that are not getting thrown out at the initial stages based on major errors on my part. I literally going to be moving to the next phase. I'm good. Trust and believe I'm good. And I have a hell of a support system. So I'm good. You ain't got to worry about me. I'm good. It ain't about me. It is not about me. It's not about me. If you want to see, well, how does your accounting really work? Do you know what you're talking about? You can watch my videos. You can watch my videos. I already posted. You can watch my videos. It's not me that has to prove anything to you. It's your gurus who you've been putting thousands of dollars into. That's who got to prove something. I don't got to prove nothing to you. You need to go back to your gurus and ask people like Miss Kenyana Stone, have you been successful or at least can show any type of progress before that master class that she had on securitization? And newsflash. Uh-oh. Somebody gave me Miss Kenyana Stone's master securitization class. And when I y'all, it's not even worth reviewing live. I will just tell you this. I'll sum it up for you. Her securitization class is the result of only getting a piece of the puzzle, but you don't really have the full picture to tie it together, which is going to lead you back down the same drain. Still dead on arrival. It's one of those things where you could be so close, but yet so far away. It's one of those things. It appears that, ooh, it's on point, but when you strip it down and look at it from a legal court standpoint, just missing a whole lot of parts. And it's not the big stuff. It's always the little stuff that people miss. So we will be finishing up the master netting class tomorrow. That will conclude 4 videos. And you may just learn how to properly attack requests, interrogatories, court case, administrative claims. You'll actually know how to start asking the right questions instead of validate the debt. Is that my identity? Oh, who's the real creditor? Are you a debt collector or a lender? None of that addresses the core issues that's going to put you in a better position. None of those questions. As a matter of fact, in a debt validation letter, if they respond to you with the information, that means they didn't escalate it up to the top. That means it didn't meet the requirements to be escalated to the compliance department. That means the servicer responded. You either want them to send you a letter saying, well, you don't owe any more obligation, number 1, or your obligation has been set off, number 2, or you want them to decline to discuss it. Now you can move to the next steps. See, that's the thing. Most people only have enough ammo to load up on that one document. And when that doesn't work, they don't know what to do. See, with the Supreme Elite Team University, we got about 10 different rounds in the chamber. We can attack them from multiple different ways. So when it never runs, like the options never run out. Like they never run out over here. There's always going to be a way to attack. And when you have more options, you have more confidence. The more confidence you have, the more hope you have. The more hope you have, the less stress you have. The less stress you have makes for a healthier life. So the new Culture Empire, and associated with Supreme Elite Team University, we're not only bringing classes to you, we're bringing a mindset and understanding. It's up to you to take the next step. With that being said, we have a case where we have a pro se litigant going up against Capital One. Like, share, subscribe, hit the notification bell. All. Don't do personalized. Hit all so you can get updates on the latest content, information regarding the Supreme Elite Team University. And if you are interested in the Supreme Elite Team University registration, send an email to thomaslegacy603@gmail.com. Without further ado,
still have other persons in the meeting. Does anyone else have a case here today?
Your Honor, Sherrod Management, that's my credit litigation specialist, O.C. Sherrod, who I'm allowing to speak if needed. So he's here with me.
What do you mean specialist? I guess I'm just not sure. Is he a lawyer?
He is part of my counsel. Been working on with this.
Do you have counsel in the case?
I'm speaking for myself.
translation. He does not have a lawyer. She's just working with someone behind the scenes.
Okay, so I'm sorry. I'm just trying to understand. Who is Mr. Sherrod Management?
Can OC speak?
Who?
Yes, can you hear me, Judge?
Yeah.
Wait, are you able to hear me?
Yes, sir.
Wait, hold up. I can't.
Can't y'all already tell where this is about to go? Can you, it's always these people that want to show up on behalf of it. What's the first thing that's coming to mind right now? Go ahead, type it in the comments. What's the first thing that's coming to the mind right now?
Can't hear you. Hold on, let me see why. Okay, are you? Can you still hear me?
Yes, sir.
I don't know why I can't hear you. Hold up, bear with me. Let me see why I can't hear you. Let me check my microphone for a second.
We all can hear you. You sound very clear.
Oh Lord, I don't know what's going on. You guys can't hear me.
I can hear you.
Yeah, we can hear you, OC.
Okay, there we go. There we go. Yeah, something was wrong with my speaker. I had to get it off the speaker and put it on the laptop.
Don't even matter.
Okay, now, yeah. Yes, how you doing, Judge?
I'm well. How are you?
I'm awesome.
So he has the Mobb Deep ringtone, I Gotta Get Away, which is one of the classic songs. So you're in a court hearing with the Mobb. Now, I'm a hip-hop fan. I'm a hip-hop connoisseur, so I have no problem with the music itself. But you're in the court setting, and you still have a ringtone with Mobb Deep's Get Away. That already says enough.
I'm just in representation here with Miss Amber Williams. No, I'm not a lawyer.
Okay, y'all. So this is someone she paid. So this is how it started. She paid him for a service. He gave her some documents to submit. She submitted the documents to Capital One. Capital One struck it down. And then she paid again, more documents to submit. They ignored that. And then she let him know that she has court. And in order to save face, he has to come to court with her.
Or anything like that. I'm just a accredited and litigation specialist. I do a lot of these cases with my clients just on as they are allowed to allow me on to actually go through these court meetings with them just in case for assistance.
Judge, please allow him to stay on. I'm begging you, please allow him to stay on. I'm begging you, Judge, please allow him to stay. I really want to see how this goes.
Ms. Thane, do you have any position on allowing what is your name, sir?
It's OC Sherrod. I've been on the previous 3 calls as well. With this makes the 4th one, which Miss Shipman, the last few times allowed myself to be on.
And y'all, this is not uncommon in cases like this, where the judge will sometimes allow like someone like him or like me to like be on the call with them and like help assist them. And the reason why they kind of bend the rules, like, because it's a civil case. Criminal case, absolutely not. But this is a civil case. So, I mean, they're a little more flexible with it. I've actually seen them they're allowed to have the assistance of someone and they speak for them in court. So I've seen it before. So it's not, I wouldn't be surprised if the judge allows it.
I didn't have to say too much in particular at this time, which this time I may not have to say anything as well. But I'm just here as a support for Ms. Amber Williams in the event that she would like me to speak on her behalf.
And as long as he doesn't come off like he's giving legal advice or trying to argue for her, I mean, to the point where it crosses the threshold of ineffective counsel type narrative. So he has to walk a tight line.
Ms. Thane?
Well, if Ms. Shipman allowed it, then I have no problem with that, no objection.
Okay. All right. We are here on a previously
Yes,
filed.
sir. He allowed it. Yes, sir. Now let's get into it.
Let me call the case formally. We're on the record in Capital One NA versus Amber Williams. The case number is Butler County 23 LM 442. Capital One appears by and through Nicole Thane. Ms. Williams appears in person and pro se. She also has appearing with her her credit specialist, OC Sherrod. Ms. Thane, Ms. Williams, we were last here on a motion by Capital One seeking that the court grant summary judgment for the prayed for balance in the case and make such and any other orders as would be appropriate. The concerns the court had were just to be able to hear in detail and from a procedural perspective, particularly what Ms. Thane for her firm thought were appropriate reasons for the granting of the summary judgment. Also, I know that there was an answer in the case earlier on where Ms. Williams had indicated basically that it was an affirmative defense in her view that she didn't owe any money in the case. I think there have subsequently been some interrogatories filed, and that might bear on the appropriateness of granting summary judgment. And I guess, Ms. Thane, I would just like you, if you would please, to kind of go step by step through the reasons that you think the court should grant summary judgment. And I can tell you that one concern Ms. Williams had raised previously was that she had sought to get some answers to several questions. I don't know if you have this document before you, but she had sought an original contract agreement with a wet ink signature receipt.
There you go. What did I tell you? That's all part of the debt validation letter. That's all part of a debt validation letter, wet ink signature, identify the account, who's the holder, is it really me? See, with the new Culture Empire and the Supreme Elite team, we bypass all those useless, waste of time like arguments and get straight to it.
Stating that she received a product or service, an original contract agreement with a wet ink signature stating that the company could purchase this debt with personal information attached, copy of collection agency license that states your company can collect the debt, proper court order or summons to court signed by a judge with an accurate court date, documentation stating that your company is representing the original creditor, and documentation that your company did not violate any laws. And so I recognize that you might be speaking to some of those issues in lieu of necessarily having a document to provide. But if you could please just go through the rationale for the summary judgment from Capital One's point of view, I would appreciate it.
Sure. Well, we had propounded discovery to Ms. Williams on June 22nd of this year for its first request for admissions, interrogatories, and request for production of documents.
Well, what? 1 second. 1 second, y'all. 1 second. Isn't that what I just provided for my client yesterday? Who is a lawyer? Who knows how to read through things? This incredible work. Must be talking about the response to the finance company's interrogatories requests. Oh, yeah. And then we hit them with our set. Oh, since y'all want it. Okay. Well, how about this? Because one thing about the new Culture Empire, the Supreme Elite Team University, we don't argue the contract. We don't argue the wet ink signature. All we're saying is, you know, we don't even owe what the contract says because you've already bam, 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 bam. So you're saying that we owe this on the contract, but behind the scenes, you're really showing that we only owe a small percentage of it.
You're rocking with the best.
Now imagine that assertion, but being able to prove it from a legal standpoint and using their own words against them. Good God Almighty.
And I say the defendant has 14 days to respond to those from the date that she receives them. Otherwise, her requests for admissions under Kansas law are deemed as admitted. And they say the statement of material facts are admitted at that time, deemed as admitted. Defendant has 14 days to respond to those from the date that she receives them. Otherwise, her requests for admissions under Kansas law are deemed as admitted.
You get that? Under the law, not what you believe, not what your guru told you, not how you feel, not how it should be, but under the law. I'm going to say this again. And when I hear gurus biting my sayings, you know where you heard it first. Court is 99.999% about rules and procedure. The other 0.5% is about the facts of the case.
And they say the statement of material facts are admitted at that time, and plaintiff's motion for summary judgment has listed the statement of uncontroverted material facts, stating that, basically stating that there is an amount owed by Ms. Williams to Capital One in the amount of $2,779.96. And that's plaintiff's basis on its motion for summary judgment, and the reason why we're requesting to have that granted at this time.
Okay. And do you?
So they're moving for summary judgment. Okay. Capital One's moving for summary judgment. So what do I always tell you? They file a complaint, in this case, Capital One. The defendant responds. As soon as the defendant responds, they move for summary judgment. Prime example, Kenyatta Stone. They filed the complaint. Kenyatta Stone responded. They moved for summary judgment. It was granted. So she has a guru here, a credit specialist, and obviously she responded, and now Capital One's move for summary judgment. They only move for summary judgment if in your response to their complaint, you did not bring up any serious issues of genuine fact, meaning it was all goobly gook, gobbly-gock, lack of understanding of the statutes, etc., etc. It's only when your response hits them to the core is where they remain silent, and the judge, in those rare cases, like me, is going to schedule a civil pretrial. Once it gets to the pretrial stages, now your motions for summary judgment, now your motions to dismiss, now all that is what the courts call a ripe and timely.
Did you at any point receive her request for the documents I had indicated, or do you have any other response to that request? It appears that she had put something certified mail. It seems to have.
Bro, why do you even still have a ringtone? Why do you even still have a ringtone? It's 2025, bro. It's not 2009.
Come back, perhaps with an incorrect address, and I just don't know if you even ever received those.
We did get that. We received sent a verification of all of we sent all the documents.
Okay.
On a
bro, mute. Goddamn, mute your phone.
I don't know. Somebody's phone keeps coming on. If you could please put that on mute, I'd be grateful. Okay, so you did answer those questions, or at least provided rationale as to what your responses were with respect to those questions.
We just provided documents that we have in our possession. I mean, as far as a wedding signature, this is filed based on an account stated, which is not a contract. It's not required to have a signature.
Okay, so account stated. So an account stated is not required to have a signature. It's not required to have an account. It's not required to have the wet ink and all that stuff, because it is called an account stated. Now, I want you to look up what account stated means. Can't wait for me just to tell you everything. Most people want you to tell them this. No, it's an account stated. It's totally different rules.
This would have been a credit card application, not a loan contract. And so there's
for the court's edification, is that something that's typically done over the phone or electronically or something like that? Is that Go ahead. I'm sorry.
Yes. And anymore, yes, most of the time they're electronic.
Okay. All right.
Exactly. So when you do your electronic signature, when you sign, and this is the thing, you do realize, and this is how I know that most people don't read their contracts and their applications, because in your application, it does have a consent to the electronic version of it. And since most people don't read it, they waive the right for the true blue ink signature. As a matter of fact, people waive it every day, especially in their mortgage contracts, especially in the 10,003 and the deed of trust. Let's go. Hold on, y'all. Let me show you what I'm talking about. This is why I be saying the things that I say. This is why I say the thing. This is why I don't know how many times that I gotta keep showing you that, like, I don't do this stuff for I don't do this stuff. Ooh, I don't want to download all security insurance. I don't do it now, for real, man. I'm just saying I don't do this stuff just to, like, I'm telling you, like, the stuff that I'm cognizant of and understands. What state y'all want to do? It don't matter. It's all the same thing. Like, hell, we'll do Virginia. Okay, so let me go back. Let me go here. Let me go back here and share my screen. Let me share my whole screen. Let me share my whole screen. Watch this. I'm going to share my whole screen right quick. Let me share the entire screen. Let me share the entire screen. Right? Everybody should be able to see my screen. Everybody should be able to see my screen right now. All right. So, and this is what I mean. And this is the stuff where these sovereign citizen teachers are going to go back. Somebody going to send in my videos, and then you're going to hear them start talking about the same things that I'm talking about in class. They've been doing it for years. They've been doing it for years. You know how many emails I got from people saying, hey, yo, they was talking about this for the past 5 years. Now, all of a sudden, you talked about this yesterday. Now they double backing on what they said and walking back what they said. Now they talk about securities. Hey, they've been doing negotiable instruments for years and all this stuff and the Elliots and all that. Now they're talking about accounting. Oh, you've been talking about all this stuff. Now they're talking about securitization. Man, I get emails and text messages for years. Oh, now they saying the 1099A don't work. You came out with a video like that yesterday. Oh, now they walking back. Like, come on, man. And that's the difference between someone who's actually put their time in. I even know what line it is. I'm going right down to the line. Look, I'm going right down to the line. That's what I'm saying. They don't take the time to get the in-depth understanding. Come on, man. If the note evidencing the debt for this loan is electronic, borrower acknowledges and represents to lender that borrower expressly consented and intended to sign the electronic note using an electronic signature adopted by borrower. Borrower's electronic signature, instead of signing a paper note with borrower's written pen and ink signature. B, did not withdraw borrower's express consent to sign the electronic note using borrower's electronic signature. C, understood that by signing the electronic note using borrower's electronic signature, borrower promised to pay the debt evidenced by the electronic notes in accordance with its terms. And D, signed the electronic note with borrower's electronic signature with the intent and understanding that by doing so, borrower promised to pay the debt evidenced by the electronic note in accordance with its terms. So when I get people, when I get people, right? When I get people that come to me that got mortgages and I tell them to send me all the stuff that they've been doing, and they come to me and I start seeing these debt validation letters asking for the wet ink signature, when I'm looking at their deed of trust and looking at line 25, in some states it may be line 26 or whatever, and then I ask them, why are you requesting this? Have you read your deed of trust? You know what answer I get? Oh. And you know what I said after that? Because you were just doing things that the teacher said instead of understanding why you're doing what you're doing. And this is what I'm eradicating from these spaces. And this is the challenge to every student, every consumer, every person that's trying to learn, that you will stop just doing because someone said do, and you're going to find someone that can help instill understanding. Because once you have understanding, you are already going to know what to do.
You're rocking with the best.
Did you have anything else you wanted to add on the question of whether the court should grant your summary? Go ahead. I'm sorry.
I'm sorry. Yes. And anymore, yes. Most of the time they're electronic.
Okay.
See? It's right. It'd be right there.
All right. Did you have anything else you wanted to add on the question of whether the court should grant your summary judgment motion?
Not on the summary judgment, but in response to her other inquiries, it's not a purchase debt, so there's no debt buyer involved. Blitton Gaines, we're the attorney for Capital One, and we're authorized to, as debt collectors, to collect debt. And
okay, so there you go. So she thought it was a purchase. See, misunderstanding of the law, misunderstanding of the rules. And now my question is, Mr. over here at the top, Mr. Credit Specialist, I know you wasn't helping her prepare these documents because you should have known all this. And this is why people come to me. This is why my emails are blown up. Because when we do things the right way, and we are following the rules and the procedure. If the rules and the procedures don't allow it, we don't do it, regardless how much you believe in the process. We don't do it.
the states that we're licensed in. So that's all that I have on that.
All right.
And this plaintiff goes requested summary judgment be granted.
Okay, thank you, Ms. Thane. Ms. Williams, what is your position on the summary judgment motion question?
Okay, well, Your Honor, I'm here today because I don't know the balance. I spoke with the original creditors, Capital One, on October 23rd. They said the balance had been satisfied and paid in full. I'm asking for this case to be thrown out because on terms of identity theft on the form of fraud, last time I came.
Once again, what did I say in the beginning? Some identity, you sold my account, fraud. As soon as you say the word fraud, you have raised the standing. You have raised the threshold. You have raised it. Now you have to really prove it. Why do so many people go to court and the first thing they want to yell out of their mouths is fraud, not knowing when you say the word fraud, their own set of elements that you have to prove beyond a shadow of a doubt, where it's more than possible could have happened, but it shifts over to plausible. It's called the Twombly standard. Bell Atlantic versus Twombly. Ashcraft versus Iqbal. And this is what I'm saying. You're throwing these words out there and not understanding what you have to do to prove it. The who, what, when, where, and how. And how did all those things cause damages to you? It's going to be hard to prove fraud when in the course of these debts, buying debts and, selling them and, doing all that. It's normal standard business practice. The argument that, well, I didn't contract with you. The court shut that argument down 10 years ago. It used to work 10 years ago. Just because they didn't prime example, Capital One could sell my company a $30,000 debt for $5,000. All I have to do is send you one notice, demand a notice for payment. And if you don't pay, I can take you to court. I'm gonna be honest with you. If I was me and my team pull our funds together or pull all our resources together, go get financing for about $1 million and go up and down these credit card companies and buy debt for pennies on a dollar, I swear to God, to you, 99% of the people be in Schitt's Creek because I know they don't know how to attack it. I know they wouldn't know how to stop it because I already know how to stop it. So we can get with our lawyer and put a master defense together. And that's one thing about understanding. You know both sides. You know how they operate, and you know this side of the field how to attack. Do you think many people out there is going to know how to attack it the way we do? I mean, we see the same arguments every day. We will shut that down. I mean, it's getting to the point where y'all handing them slam dunks when the whole time it's all a smokescreen. They're really weak for real. You break down that firewall, they are weak. Their case starts to crumble the longer it proceeds.
Ms. Shipman said that they are the attorneys for Litton Gaines. I asked Capital One, they don't work with third-party attorneys. And the first thing was I also had sent them 3 professional letters.
What debt collector does Capital One use? Usually they first try to collect the debt via their in-house collection department. Then they send the debt to an outside collection agency such as National Recovery Systems or Trans World Systems. If both are unsuccessful, then they send the debt collection to law firms in New York.
Before anything, asking them to send a contract over showing that the wet ink signature. And then I also, for the identity theft and fraud, there wasn't a contract.
I think it is balls. Yeah.
Saying they could purchase my information. And I know in the state of Kansas, you can't have somebody's information without their consent and then come back and try to charge them to profit after me. So I've spoken to Capital One a couple times, but the last time was October 23rd when we.
Okay, this is the difference between knowing litigation and not. As soon as she would have said, I've spoken to Capital One, speaking to them on the phone means nothing unless you got documentary evidence to prove it in court. She's supposed to be submitting that to the court, and the other side should have already had a copy of it. You get what I'm saying? Everything has to be, that's why it's all about procedures and rules more than the facts.
We had the last case to confirm that I don't owe the balance. They said it was sold to Litton Gaines, and Ms. Shipman said last time that they are the lawyers for Litton Gaines. They are not the lawyers for Capital One. Capital One does no longer, they are the original creditors, not Litton Gaines, and I have not purchased a product or service from Litton Gaines. I don't even know who they are. And Your Honor, also.
And this is one of the beautiful things about the master netting class, which is ongoing. Let me just tell you this. As soon as there's a charge off, a transfer, a sale, right from that point, we're going to be able to prove from a legal and accounting and court precedents that Miss Amber Williams legally no longer owes. And we're going to evidence her legal basis for not owing by using their own words, using them to prove it. Sheesh.
And I have not purchased a product or service from Litton Gaines. I don't even know who they are. And Your Honor, also, I'm here because I'm fighting this because I have had my identity stolen before 5 years ago. And I'm just now getting back on my knees, like fixing things. So this was very alarming to me. I don't even know who Litton Gaines is. I've never done business with them. The original creditor is Capital One. I have the guy's name, Jamal, and his ID from Capital One. If you would like to call the 1-800 number and speak to him.
No, you were supposed to get documentary evidence for all that. How they're going to call and speak to them? That doesn't even make sense.
Okay. Ms. Thane, do you have anything by way of response to Ms. Williams?
Okay, yes, Blanton Gaines is a law firm. I work, Ms. Shipman works for Blanton Gaines. Blanton Gaines represents Capital One. Capital One filed the lawsuit. Blanton Gaines filed the lawsuit on behalf of Blanton Gaines. Blanton Gaines is not by debt. And
so basically, Blanton Gaines is bringing the suit on behalf of Capital One. So, Miss Amber, I think you're thinking that they're two separate entities, which they are, but one is working for the other because Capital One has to be represented by someone. Like you can come in yourself and represent yourself, but if Capital One was suing like your LLC, you wouldn't be able to come to court and defend the debt on behalf of your LLC. The only way you'll be able to spend that is if you were personally liable for the debt. Then you could come dispute. Some courts may allow you to do it.
I mean, and we requested all of the information she gave, she should have answered in discovery.
Right there. Discovery. She should have answered in hey, what is she saying? What you want to know what that's going down to? You know what's boiled down to? You want to know what's boiled down to? Procedure. Procedure.
You're rocking with the best.
They never, ever counteract your legal arguments. They're always going to attack you from not following the procedure and the rules. Hey, they should have answered on discovery. Hey, Your Honor, they didn't do this on time. Hey, this doesn't fit the format. Hey, Your Honor, they didn't do this. Hey, Your Honor, they waived it. They didn't respond by this time. They don't ever talk about your facts. They're only going to hit you from the procedure and the rules. I don't know how many times I got to tell people this, but just because I'm not talking the language of free, quick, fast, and I use terms like highly complex, many moving parts, a lot of nuances, the mental laziness, and a lot of people's gonna be like, man, I don't want to take that, man. I did blah, blah, blah. They already, I ain't gonna be able to do that. I need something right now, quick, fast, hurry, right now. And this is the reason why 99% lose and only the 1% ever gets to the next stage, like me.
Discovery was not answered, and therefore plaintiff is entitled to summary judgment today.
So you didn't even you didn't even answer the discovery? Can you imagine what my discovery would have looked like for her? Oh my God.
If she happens to be correct that somehow Capital One is no longer showing that she owes a balance, and I grant your summary judgment motion today, what would happen at that point?
Then Capital One should relay that information to us, and if we would have to vacate the judgment.
Yeah, that's true. If Capital One says she doesn't owe, then yeah. If she can prove that they don't owe, that she doesn't owe, and Capital One says she doesn't owe, and Hit and Bangs, whatever their name is, if they're operating on behalf of Capital One, then yes, Amber Williams will have that seems like a legitimate claim. Like, what are you doing? They already said if they're working on behalf of Capital One. So either they're working on behalf of Capital One or they brought the debt.
But that's not information that we've been given.
Right. I just wondered, I mean, she said she'd made the call, and if that is correct, what they're telling her, then the motion or the order would be vacated, and it would show as having been paid in line with what she's explaining that her call to Capital One has told her to expect. Is that right?
Yes, it's right. Don't try to think of an answer. Yes, it just makes sense.
If it's been paid.
Right. Okay.
This is the same that they're speaking.
Right. Okay. Well, if there's nothing further from any of the parties, I think that, Ms. Williams, for your part, you've done a good job of explaining and bringing some heartfelt conviction to the consideration you want the court to make, that you don't believe you owe this debt, and you have some challenges with some of the methodology that had been at issue. And at the same time,
Your
when
Honor,
you receive the interrogatories, yes,
Don't see, this is the part. Okay, I know this is the part where I know she feels it may be slipping away based on the judge's, the energy and the spirit of what he's saying. But this is the part where you got to remain cool. And I know she wants to get it in, but the problem that she's facing, the procedural hurdles, is she didn't respond to the interrogatories, nor did she respond to the discovery. That is her procedural misstep. And I told you, many of pro se litigants are going to lose their cases way more on the procedure and rules rather than the facts of the case.
can I have OC say something on my behalf also?
Oh, she need a lifeline.
Am I able to have him say something because,
that's fine.
okay, OC?
Hey, how you doing, Your Honor?
I'm good.
Awesome. So one of the things that and I definitely understand what Miss Stan is saying on her end, and what I just basically really think it is, because I've been on the phone with Miss Williams the last 2 times. We called Capital One together, and she allowed me to speak with them on her behalf to the gentleman we spoke to, and we spoke to a young lady before then. And what Ms. Stang is basically saying is that Capital One filed the lawsuit. So the thing is, what my thing is, if they actually were the ones who filed the lawsuit, and once we called them and the balance was satisfied between Amber Williams and Capital One. So even if she actually would owe the debt to Capital One, not actual Blitting Gaines. But Blitting Gaines is actually, since they saying that they are the lawyers for Capital One, Judge, and you can correct me if I'm wrong, an actual law firm that's representing the client, which is Capital One, they would not be the one actually collecting the debt. Blitting Gaines is the one that's asking Miss Williams to pay the debt directly to them, versus the debt should be paid directly to Capital One. And the debt to Capital One was satisfied. Now, the reason why Capital One did not notify Blitting Gaines is because Blitting Gaines is not actually a lawyer representing, their firm is not representing Capital One. Capital One has their Fortune 500 company, so they have I forget the name of the law firm that actually supports them, but you can Google it. It's public record, but it's not Blitting Gaines. Blitting Gaines actually purchased the debt from Capital One in lieu of trying to collect for their own benefit.
Now, okay, I'm following that. That makes sense. That's why I said it's either they're representing Capital One themselves, or are they or did they purchase the debt and trying to sue on their own? So if you really want my opinion on it, I think that Blitting Gaines are trying to pull a double whammy. That's what I think. I think that they're trying to sue on behalf of Capital One, but in the same time, they have a financial interest in this as well. You get what I'm saying? So it looks like they're trying to have it on both, lock themselves in on both ends. And this should have been a major discovery issue and interrogatories that that Amber Williams should have tackled at those stages.
Because if you're representing somebody, if I'm a lawyer, I can't take money from the actual person who owe the person I'm representing. So basically what I'm saying is Blitting Gaines, based on the reactions that they have had with Miss Amber Williams, all of the paperwork that I have seen, it's actually them trying to collect debt for Blitting Gaines. They're not trying to collect the debt for Capital One, because if that's the case, Amber, as she already did, has satisfied directly with Capital One. So, and Capital One is not going to notify Blitting Gaines of that, because they're actually not the representatives of them. If so, then what we were asking them in some of the paperwork that she sent them is for, what she has the right to do so, is ask Blitting Gaines to show the actual paperwork where you guys are actually representing Capital One directly. And if
that should have came out at discovery. This is part of your interrogatories. This is part of your discovery. Remember, I get the arguments. I understand everything they're saying. I understand it. The problem is there are stages and procedures for these things.
if you guys are, on the 3 occasions that we spoke to them, the last guy, Mr. Jamal, wouldn't have told us, and he was a manager that works in the office. He would have not told us that Blitting Gaines, and he clearly told us that Blitting Gaines is not representing them. But they did sell the debt to them, but they are not representing them as as their lawyers, and that's why we got his information. So if we have to call him, put him out, and he can actually say that either a typical manager or supervisor from Capital One will be able to tell you that as well.
Right. Anything you'd like to say, Ms. Thane?
Yes. The evidence that we represent Capital One is in the petition. Again, Blitting Gaines are not debt buyers. We did not purchase this debt. Capital One hired us to, yes, collect on the debt. And if we can't collect on the debt, they hired us to file suit. And so we filed suit as evidenced by the petition.
It's a demand letter. Once again, it's the same thing as if they bought the debt on their own. It's a demand letter. It's a demand letter. You send a notice of demand for payment, and then if they don't do that, then you can proceed to sue. So you know.
And this has been researched. The dispute and fraud claims have been put in a number of times on this case, and each time Capital One comes back to us and says no, that this claim is denied. There's been a history of payments on the account, that there's no evidence of fraud here.
And that's one of the biggest things that I tell people. When you make payments on the account, you might as well have validated it. When you can't make payments on the account and then turn around and say, I don't owe it. It ain't mine. You just cannot do that. What you're supposed to do is, number one, you either bring the account current, or you file a lawsuit as the plaintiff, or when it gets to them filing a suit against you, you tell them, you show from a legal standpoint why you are legally not entitled to pay. And you can't come with anything beyond a shadow of a doubt, because the contract is the major firewall that most pro se litigants have a hard time breaking down. The Supreme Elite Team University, we break that down with ease. But I'm just saying, for the average person out here that's trying to learn.
Or dispute. And again, is this fraud or did she pay it? I mean, I'm hearing conflicting things here. We didn't receive any discovery back. from her, and Mr. Sherrod is not an attorney, so it doesn't sound like he knows how this works either.
Uh-oh, he caught a stray because he damn sure wasn't talking like a lawyer. She caught that too.
We didn't receive any discovery back from her, and Mr. Sherrod is not an attorney, so it doesn't sound like he knows how this works either.
Absolute facts. He did not sound like an attorney. He did not, because he was still missing all the key elements himself. But this is what these gurus do. They get you to think like they know what they talking about. All this, as soon as they get in the court, they ain't no better position than Amber Williams. Look, now she's looking at him like, you motherfucker. I paid all this money to you. Look at you. You better do something.
Well, he might be experienced in the area, but I think that the important thing is he had a concern about the relationship with Blitt and Gaines to any prospective collections or to any debt. And you, as an officer of the court, have explained that you're serving in a representative capacity for Capital One. I think that the primary bottom line thought that this court has is that Ms. Williams, you've, like I said, done a good job of presenting your concerns. I do understand where Ms. Thane's coming from.
I told you, so close, but yet so far away, because the judge is about to school her on the same things I be trying to tell people every day. Now listen to this. Watch his ruling. I'm saying this for the first time with y'all, but I can see where it's going because I've been there, done that 1,000 times with this stuff.
In terms of feeling like a couple of the things you said are a little bit in tension, but in any event, I think you have sought help from a knowledgeable person. But at the end of the day, you were sent interrogatories, which
procedure
have the effect of serving as an admission
procedure
to various aspects of the case, including not objecting to the debt in question.
Procedure? What did I say? You were supposed to respond and interrupt the procedure.
I am going to grant summary judgment.
Procedure. She lost on the procedure.
You're rocking with the best.
What did I say? Her facts, and I believe what she's saying is true, but she didn't follow the proper procedure, and I'm going to say it again for those in the back. Court is 99.99% more about procedure and rules rather than the facts of the case. She did what every pro se person that I ran across, seen online does. They focus so much on the facts and what happened that they neglect the rules because they think all they got to do is go to court, tell the judge what really happened, and that's supposed to be sufficient. She didn't respond to the interrogatories. She didn't respond to the discovery. Those are deemed admission under all laws in the United States.
I am going to grant summary judgment in the amount of $2,779.96. I would like you, Ms. Thane, to please.
Right there. What did he say? You did not object to the debt in question. That is the first thing we do. Now, I don't give a damn if you're on a contract. I don't care if they got a hair follicle, a DNA sample, a thumbprint, your birth certificate, your SSN, a picture of you signing a contract. We're denying from the beginning.
Include a sentence that if you receive after the fact word from Capital One that this debt is indeed already fully satisfied, a motion to vacate the judgment will be filed.
And you know what's going to be so hard about that? is that they work together. Then Capital One is not about to cut the legs of this law firm for them. They're going to give her the run around and spin around. They're going to act like they never said that. They're not going to put it in writing for them. They're not going to do it. Now, if they said it was satisfied, I'm trying to figure out why didn't she have proof of payment to show the judge? You get what I'm saying? Your Honor is satisfied. Here's the proof of payment. Like, I don't get that. So, absence of any paper trail, she should not hold her breath on Capital One providing that satisfaction in writing.
I think that would speak to Ms. Williams and Mr. Sherrod's concern that Jamal had indicated that to them, and we'd be a step ahead of the game if that comes your way, if that's just included in the original journal entry.
Okay, will do.
All right. Thank you very much. And if there's nothing further, we will be in recess.
Thank you.
I mean, I don't know how many times I'm trying to tell y'all.
Are you
Hold on.
in as published writer?
Before we move that,
Yes.
before we get there, public service announcement.
Hi, I'm Jim Bullock. Ever wonder why so many pro se litigants lose in court? It's simple, ridiculous, and stupid. They refuse to follow the rules.
What did you say? What did you say? Because pro se litigants, they don't think the rules apply to them. They think that how they see it, and they can just do whatever they want, and the judge's supposed to just agree with them because they're right. What did you say again, sir?
To follow the rules.
They what?
No, they refuse to follow the rules.
What?
They refuse to follow the rules.
What?
They refuse to follow the rules.
Okay.
No judge in this country is going to rule against his colleague and fellow bar member. We can easily and legitimately rule against you because you have failed to follow the rules of court, especially when they're available online for anyone to read and understand.
I couldn't have said it better. So when people send me emails talking about, why are you calling people mentally lazy? Those are the hit dogs. Everyone who sent me an email, because I use the term mentally lazy, those are the ones who are mentally lazy. It hit to their core. So when I say mentally lazy, when I'm saying a lot of what you need to know and understand is available online, but just because it speaks a different language, it may be too long, people's attention span is short, they rather try shortcuts than going through the vigorous process that at the end of it, you have way more understanding and knowledge of the system, so you won't continue to be making the same rookie mistakes that people make, whether they've been in this process for a year or 20 years. It doesn't matter. They all still make the same rookie mistakes.
Most collection attorneys are granted summary judgments because the debtor didn't file an answer or motion to dismiss.
What? Didn't file an answer or motion to dismiss? That you said, hold on, sir. You said a lot of summary judgments are granted because the debtor didn't file an answer or a motion to dismiss. Is that what he said? What's good, y'all? So this was in response to my motion to dismiss because my client was being sued by a company that purchased the debt, and they filed a lawsuit. She owed $17,000. I filed a motion to dismiss, knowing that it was premature, knowing that it may get denied at this stage, because if you look right here, judge's response. But what most people don't understand is that I have top elite court litigation skills, so I really filed this motion to set a trap. So I was ordered to respond. So you can imagine that, well, if they denied your motion to dismiss, and everything in this response was the same thing I filed in my motion to dismiss. See, I set a trap not only for the company, but for the judge too, because I know court strategy and how to structure a motion where the judge is basically can't even rule against me. Now, most people would say, well, if you file the same things, double down on your position in your actual response, then to your motion to dismiss, there's no way that the case is going to move to pretrial or a conference. They're going to get awarded because you didn't win your motion to dismiss, right? But like I said, I set a trap. Now look at the yellow highlighted. You see, I pretty much handicapped the judge and not giving them a judgment right at the beginning because they wanted a judgment. But what I did with the motion to dismiss, I laid the trap, and then I came back with the response that pretty much handicapped the judge. Now it's our turn. Now we're about to move for summary judgment. And this is going to be another victory. New culture. According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
The new culture empire, where we set standards, raise the bar, and executing greatness right in front of the low-hanging fruit.
You're rocking with the
Thomas'
best.
legacy as Pro C is on legendary status. And if you ain't know, it's the new culture
You're
empire.
rocking with the best. You're rocking with the best.
The rules state that any claim stated in the complaint is deemed true unless denied.
And what did she not do? She didn't respond to the interrogatories or the discovery. So in any state, it's deemed to be true.
You deny via an answer or a motion. No answer or motion, the judge does exactly what the rules require him to do, grant a summary judgment.
And this is what happened to the video we just watched.
Want a chance to win? Learn the rules of court. Then learn how to prepare a valid and effective motion to dismiss, answer, counterclaim, and affirmative defenses.
Damn! You're saying everything that I've done. You're saying everything that I've done.
Learn the art of discovery, how to ask the right questions, demand the right documents.
Don't I always say that? Rules of discovery, rules of evidence, what to ask for, what to say, how to properly style it, what to put out, what thresholds you got to meet, what standards, case citations, authoritative, court precedents, regulatories, academic. Yeah. And this Supreme Elite Team University is going to prepare you on how to do all that. Because I'm gonna be honest with you, y'all have been misled into this fairy tale that this is going to be quick, fast, and all you gotta do is file a document and the keys of life's going to open for you. But the thousands of dollars that y'all spent on these dead on arrival packets, the hundreds of dollars that you spend on consultations just to get regurgitated information that person learned, the hours you spent researching things that were going to lead you to a dead end from the outset, the days, weeks, months that you're sitting back hoping that it's all going to go away. The one thing that's been missing throughout your whole process is a proper foundation and understanding. Because when you start your process just by buying a packet or just taking someone else's word, no matter how long you've been in these spaces, you've never established a foundation. Whether you've been in here 5 years, 10 years, or 30 days, it's easy for me to see whether a teacher or a student has proper foundation. So if it's easy for me to see, it's way easy for the attorneys in the courts to see.
Let the bank prove your arguments for you.
I think I missed what he just said. What did he say?
Very few people are
What did he say?
arguments for you.
What did he say?
Demand the right documents. Let the bank prove your arguments for you.
What?
Let the bank prove your arguments for you.
What?
Let the bank prove your arguments for you.
Didn't I say that 20 minutes ago? To substantiate one from a legal standpoint, we're not obligated to pay this amount, and that's I'm going to use their own words to substantiate what I'm saying. This is what I'm talking about.
Very few people are defeated by brilliant lawyers. Most people are defeated by their own ignorance.
That's a fact.
By brilliant lawyers. Very few people are defeated by brilliant lawyers. Most people are defeated by their own ignorance.
What?
Very few people are defeated by brilliant lawyers. Most people are defeated by their own ignorance. The choice is yours. Hope this helps.
That man ain't tell
In the following, while court is in session.
That man ain't tell none of you anything wrong. He said exactly what I tell people day in and day out, night in and night out. He said exactly.
Okay, let me
That's
go.
fine. I'll let you in now. We don't allow observations in Zoom. They have to go to YouTube. So let me let you in, okay? Okay. And then do you have a camera?
I do.
There. Okay. All right, perfect. So I know when we were here last, I had given Ms. Quinata some additional time. I know you had asked to speak with counsel. I haven't seen anything, so why don't I start with you on your ability to obtain counsel for today?
Sure. I decided, I already did everything that I needed to do.
Okay.
Sorry, can you hear me?
Yes, I can.
Okay. So I decided that I already filed everything that needed to be filed. I don't know. I can't remember first of all, I want to apologize because I wasn't feeling very well last time I was in court.
You are fine.
That's the first thing I want to say.
You are fine. You sound like you still might be a little bit sick, so.
A little bit, but I'm getting better. That's all that matters. I'm getting my voice back.
Good.
But I wanted to say that I already filed everything that I was supposed to, but I can't remember if I filed a roommate release. Matthew Posner actually moved out last year, and I took full responsibility of everything. So I did want to say that on record.
Okay.
And then I also filed a quick deed claim, and that's actually in Cowlitz County Auditor's Office already.
Welcome back, everyone. Today, we're diving into one of the strangest property battles you'll ever see in court. At the center of it, we have Annette Jackson, the rightful homeowner who recently finalized her divorce. And on the other side, we have a woman claiming rights to Annette's house without ever having a valid lease or ownership papers. If that wasn't dramatic enough, she's about to argue that she paid off the mortgage with something called a trust fund and a 1099-A form. Yes, you heard.
Okay, so what's up, y'all? What's up, y'all? What's good, y'all? What's good? What's good? What's good? Let me pause right there for a second. Yeah, can y'all understand the guy that everyone on Facebook slandered your name? You can't listen. When you have top elite knowledge and understanding, when you have professionals that you're working with, when you have the top of the top stamping everything you put out, everything you teach, when you have someone in your group that's connected to an ex-SEC attorney who was the number 2 or 3 on the totem pole at the SEC for damn near 3 decades, when you have someone in your group who's connected to an ex-World Bank examiner, ex-FRB examiner, ex-top Deloitte official, one of the big 4 in accounting, there is nothing that a sovereign citizen online struggling to make ends meet, getting cars repossessed, got so desperate, gotta file negotiable fake Federal Reserve routing numbers with your social security numbers and coupons to pay your bills. How can any person of that magnitude ever be slandering my name? How and let me ask you something. This person came from one of that was watching Kiana Stone when she went live. Why didn't she go to Kiana Stone? And this person had court today. So over the weekend, we got her together. Why couldn't Kiana Stone do that? Huh? No. Can't slander my name. The only way a name could be slandered is if you believe it. You think I care what someone believes who ain't getting nothing accomplished? Huh? You think I care? Like, I ask yourself, why would I care? The proof's in the pudding. Denying. Kiana Shakur Stone. This person can slander me? You talking about this? It's no way. Like, the only way, it's to the point where, like, I'm be honest with you. The only way someone can really come and prove something against me, it got to be another professional. I'm not even lying. Like, you got to be a professional for me to be like, all right. Now, you really have to be a professional. Because people like this, it's like, it's no point. It's no point. Like, you literally got to be way out my league for anyone to pull my coattail. Nah, for real. And that's one of the things, like, y'all gotta understand, like, everybody is not everybody is not just like you literally got to be able to pull my coattail. So everybody talks mortgages and stuff. You get what I'm you're like, is the picture starting to set in a little bit? You get what I'm saying? Is the picture starting to set in a little bit? And with the video, with the phone call afterwards, with the follow-up, it's actually on my page. See, they want to slander with just talking to you. They want to slander with just talking to you, but they don't want to slander with the receipt. Yeah, go ahead. Look. They hate when the receipts come out. They always want to leave when the receipts come out. They always want to leave when the receipts come out. But this y'all guru, talking about slandering the name, this her. Letter of instructions, remittance advice. With a negotiable instrument. Look, this is how I know that people are still rookies and nowhere near the Supreme Elite team, because they still so deep in negotiable instruments. It has nothing to do with it. It's not even a negotiable instrument. This the problem. See, she should know this. She knows securitization, right? What date is this? March 22nd, 2023. So she became a securitization expert in 2 years, when it takes most people about 7 to 10 years to master it. She became an expert in 2 years, acting in good faith. Please find the negotiable instrument remittance coupon and money order to provide special tender of payment to JP Morgan. This is a tax matter that requires your prompt acceptance and response within 10 days of receipt. Tax payment money order is legal tender exchange according to the Bill of Exchange Act. Are you serious? You really think a person like this can slander my name? Are you serious? Why didn't they slander all those receipts I dropped on their pages? They ain't slander that. You see that? So she's taking a consumer finance transaction and transposing them with the Bill of Exchange Act. Nobody who does this can ever slander my name. You know, they don't even comment on my page. But every time someone talks, I'm just going to drop a receipt. Every time someone talks, I just drop a receipt. Every time someone talks, I just drop a receipt. Every time someone talks, I just drop a receipt. So the audience can say, well, damn, this person is talking, but every time he responds with a receipt. And this is when you get about 10 to 15 people that was in her class sending me emails asking for help. Asking for help. Look at that. Another one. You see that? Pinch the screen. Sovereign Sit Guru, Kenyatta Stone with their coupon method. I thought your guru had degrees. I thought your guru had degrees. Ain't no way. Hey, listen. Ain't no way she got degrees in doing all this and no securitization and accounting. Ain't no way. Ain't no way she know accounting doing this. It could work. The low-hanging fruit does stuff like this. People who ain't got money to pay their bills, or people who ain't got enough money to hold themselves over until they get what they, to the process go through. But let me ask yourself a question. How can someone be slandering my name when on their Facebook page, they got these degrees and all these accomplishments, been in court? You see? How can you slander that? You see? 4 children, family income $200, a nail tech, self-employed, 1,093, give food stamps. Please let me get around paying this filing fee. She ain't even pay one filing fee, all the lawsuits she filed. You mean to tell me you are a decorated accountant in all these fields? You mean to tell me that as being as decorated as you are and got all these degrees, you can't pay the filing fee? You mean to tell me with all these degrees and stuff that you got, you mean to tell me that every time you go to pay a bill, you're always never just paying with real money? Like, you don't even want to put equity into it? Hey, what if you used to get a set off? You get a return of all that stuff that you did. Look, stamp at the bottom of it. Like, how can a person like this ever slander my name? And the people that brings me the information when you was in there live, did anybody say, well, go tell him live? I sent her the link. She never pulls up. She has me blocked. Why would you have a person blocked and then continues to talk about them? Because you're trying to spin a narrative? You don't want me to pull out those real receipts on you? Huh? And this was just 3 months ago. So how you all of a sudden an accounting guru? I mean, like, they ain't none of my shit taken. The finance company ain't come take my shit like they took hers. The finance company couldn't take my shit. I ain't make a payment since July. Hell, they don't even want to talk. They so backed up in the corner. They don't even want. Still got all my whips. Where's hers at? They came and snatched hers. I got my whip. Huh? 2 GLE 350s. Still got all my whips. Where is that? Where her whips at? You see what I'm saying? Where her receipts at? And any one of these gurus, where their receipts at? Where are their receipts at? Huh? Somebody tell me where their receipts at. Any one of them. Oh, they said, oh, I know how to help with mortgages. Nah, we ain't playing. You know what it takes for you get there? You know what it takes for you get there? Clerk of the court stamp. You got to pass the sufficiency test. You got to pass the court's major screenings. You get what I'm saying? How many of them ever gets to this stage? You got to go to the court to pick up that form to serve them. How many of them ever get to that stage? My case wasn't thrown out at the beginning. The judge ain't denied my complaint. And my complaint was hella detailed, evidence and fraud and all that. Huh? I ain't had to file a motion to reconsider and get that denied. Huh? 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 Every time they come with talk, I come back with receipts. And this is the problem with this space. Y'all get so used to just believing and only believing in one way and only want to do it one way. Only want to do it the one way that you believe. So anytime someone comes in a different manner that you don't you know what I'm saying, don't believe in, you're so quick to strike it down because it's a process you don't understand. And this is why a lot of y'all fall for the okie doke, because you only want to do processes that you believe. You don't want to follow the rules and based on what the rules say for what it is. The only process that y'all want to partake in is the process that's off your belief system. And then you wonder why you send your letters to the mortgage company, you send your letters to the auto company, and they steamroll right over top of you. And they steamroll right over top of you. You send your documents in, they still collecting. You send your documents in, they still collecting. They still send you a notice. Stop sending this fraudulent stuff in. You send your documents in, they still coming after you. But if she knew accounting like she said she did, I'm trying to figure out why she got to send negotiable instruments. I mean, for them to stop demanding payment, all it took me was an email and a masterpiece of their accounting. That's all it took. And it was a masterpiece. If Kenyatta Stone would have the documents that I sent to credit acceptance, she would be revived. She would be revived. But you want to know what the real problem is? You know what the real issue is? She wish she had a man that could actually send her that much. She wish she had a husband that can actually send her that much. She wish she could have been on the beneficiary of that. She wish. That's the real issue right there. Forget the processes. That's the real issue right there. She wish she could be on the beneficiary of that. She wished she could have been on the beneficiary $77,112.53. Not to mention all the bags, not to mention all the clothes, not to mention all the shoes. Not to mention, hey, stepping the game up, upgrading it. Not to mention being equally yoked. Not to mention being equally, not to mention, I mean, we can really pull out the deposit receipts for the past 2 years. I can just do 6 months. She can run it back 5 years. I let her go back as far as 5 years. I guarantee you a lot of money and checks that a lot of people are waiting on one lump sum from the IRS. I guarantee you a lot of people, the amount of receipts that I have are what people are waiting for every day from the IRS or some type of fraudulent process. I guarantee you. So the next time somebody wants to come pull my coattail, especially on Facebook, and then you got me blocked because you really don't want to clap back. You really don't want to go back and forth. And just tell them, anybody, the new culture empire says you got to come with receipts. You got to come with what you actually done, what you are actually doing. What is the standard of their groups? Who's really understanding anything? Who's really learning anything besides a step-by-step, do this, do that, say this, say that, put this in this box, put the stamp right here, scratch off the number on the money order, you write your amount here, hey, use your social security number as the route number, put this here, send that all to them, debt validation this, debt verification that, prove the debt was me, debt collected this, debt collected that. What are you actually really learning? Because I can show you the stuff that people are saying. They're in my emails. I'm not going to share private emails because, you know, that wouldn't be right. But a lot of stuff that people been sending to me, they been sent it to me. They've been sent it to me. I just now got to it. But this is y'all guru, though. This is y'all guru. Remember, this y'all guru. This, let's not forget. This is what she on. This is what she on. I ain't on that. I ain't never tell nobody to do that. This is what she on. Hey, tell me, hey, tell her, come, hey, come on, man. Come on, man. Look at the whip. Show him the whip. Show him the whip. Come on, man. Like, come on, stop playing, man. Me and my wife done blew more fucking money than they would love to see. Me and my wife done blew more money than what they would love to see. Come on, man. They gotta stop what they doing, man. They gotta stop. Hey, tell them I said stop the shenanigans, man. They gotta stop the shenanigans, man. For real. They gotta stop the shenanigans, man. The shit don't make no sense, B. Nah, they really gotta stop the shenanigans, man. Like, we could really pull up in real life, man. Matching. Everything always matching. Like, you really pull up in real life. You could really pull up on the new culture in real life, man. Like, there's no facades, ain't the internet. We could really pull it up in real life. People from my group done pulled up on me. I meet up with members in my group. I meet up with members in my group. Nah, for real. I meet up with members in my group. I'm not that type that you can only get access online. I'm not that type. I ain't that tight. Me group members can pull up on me. Like, I have nothing to hide. I'm very accessible. Like, I'm very accessible. But what it boils down to is they do not have the top elite knowledge that I have, for the sole purpose of they have not put the time in the years in that I have. They all started out from a group. They started out with getting a packet. They started out with someone telling them, someone showing them something. They never did the research for themselves, and it's coming out to be exposed. As a matter of fact, I don't have to expose it. I'm going to let them say it themselves. 1 second. 1 second. I mean, they always going to try it. Oh, maybe I have the wrong angle. Right there. Diamond. Diamond. Look. Yep. Hold on. Do another one. Diamond. All right. Yeah. You got it? Yeah. Yeah. I got you. Let me get that. Well, then let's see. Yeah. We're gonna let her, as a matter of fact, we're gonna let her show you. I'm gonna let you hear from their own mouths. I'm gonna let you hear from their own mouths. Let me pull it up. You know me, man. Preparing one file. Actually, you know what? I think we anyway. I think files. We're gonna let you see. We're gonna let you see. We're gonna let you see. It's down here in the files. It is down here in the files. What's up, baby? What you need?
Want to get the girls?
Yep.
And
we going out to do some shopping now? Are we going out? What's up?
it's late.
I want. Yeah, you can. Yeah, we go. Yeah, I'm gonna need you to. Yeah, well, I don't think. Yeah. The pineapple iced tea, if you could. I don't know if it's. I don't know. I'll be honest with you. Yeah.
All right, I think I gotta stop over there anyway.
All right. Do you want me to send to you now?
Yeah, because he's gonna be on the phone.
All right. You see what I'm saying? You see? Shit. You talking that? That's all you needed? Can you understand? Can you understand? That's all you needed? Can you understand? That's all you needed? That's all you needed, Miss Stone? Miss Stone, that's all you needed? Why didn't you just ask? If that's all you needed, why didn't you just ask? Miss Stone, if that's all you needed, why didn't you just ask? That's all. What's that for? What are you trying to do with that? Huh? What are you trying to do with that? What is that for? Nah, let's since we want to talk, what's that for? What's that right there? Can somebody explain what the hell does that mean? Can somebody explain to me? What does that mean? Because I'm trying to figure that part out. What does that mean right there? What is that right there? Somebody explain. What does that mean? What does that mean? I'm broke. What does that mean? I ain't got no money for real. What does that mean? I'm struggling. What does that mean? I gotta sell these packets to stay afloat. What does that mean? What does that mean? I gotta take care of all these children. I know it's presented one way online, but when I'm off camera, this is my real life. I gotta do this shit. I gotta do this shit. Because I ain't got no other way. I gotta do this. This is what I call the struggle process. Oh yeah. I think a lot of y'all students, y'all really be in better positions than the teachers, but they make it seem like they in the top position, but really they need y'all 100% money to stay afloat. That I don't want y'all to lose aspect of that. They need y'all 100% money to stay afloat. I mean, they have nothing to leave to their kids. They're not the beneficiary of an estate. They're not made the executor of their parents' estate. Like they don't have nothing to leave. They don't know. They talk about wealth. They're not passing generational wealth down. How can they be passing generational wealth down doing this? How can they pass generational wealth down doing this? Huh? How can they pass generational wealth down? What type of person are they when their parents don't even want to leave them with everything? Huh? Their whole life, their whole hard-earned life earnings, they don't want to leave them. Huh? Like let's talk about it. Since everybody got something to talk about, let's talk about it. See, a guru in their own group, but students, just like the rest of the students in their group and other group. What's overwhelming to me is knowing what claims to make and setting it all up, because it's be seeming like so many moving pieces, just making sure you can actually have a claim, because y'all be spot on. This is just 3 months ago, and you got a securitization class. What? You don't know what type of it's overwhelming? Now I get it. It's overwhelming? Why is it so overwhelming? I thought you put the years and the time in studying. Why is it so overwhelming? You see what I'm saying? They can't really, what can they really say about me? Like, I don't do this stuff they be doing. Like, we not on that over here. Like, you remember, I get fact checked in real time by the top professionals. Yeah, the thing is, I don't even be dealing with different claims because I really don't be in consumer space handling credit or disputing. I've just as recently came back to that space. But you got to, so you just came back, and this is from 90 days ago, and you already selling the securitization class, master class of security. You know how long it takes to really know the ins and outs of it? It's like at least 15 different players in the securitization, 5 of which are important to you. The instrument changes names and terms about 4 different times. Is that in your securitization class? I've just recently came back to the space because all of you have been more open and detailed to how and what to do versus these people. Told you, it's all about what to do, how to do, what to say, how to say. No understanding. Told you, all teach what to do, how to do. Oh, yeah. And I dropped my receipts on Trinity 7. I dropped it on the page because everybody, oh, I'm in the debt collection debt. I just started dropping my receipts. I don't even do that. I just started dropping them. I've only done 1 claim outside of that, but that's because what I experienced with Navy Federal taking my money. So I was like, do I just let them get away with actually taking my money? or take what I've learned and trying to at least fight to get it back. Does that sound like a confident guru? Does that sound like a confident guru? No way that sounds like a confident guru. No way that sounds like a confident guru. That's a confident guru? That's what people following? Is that confident? Huh? Are you serious? Kiana, you know, hey, you got sometimes you got to find yourself, you know, someone that can, you know, help be an addition to your life, girl. It ain't that bad, you know what I'm saying? It ain't that bad, you know? It ain't that bad. I mean, you know, you got to be held to esteem, you know, when, I mean, got to be held to some level of esteem if they leaving everything to you. If you're handling the whole estate, I mean, your people's gotta have some type of reverence to you. Let me move the ticker out the way. You know, your family must hold you to some type of esteem. They're leaving everything to pass the generational wealth down. Because all it's going to do is get passed down to my kids. And they can pass it down to their kids. See, yeah, you talk the generational wealth. We actually in the midst of it. You know, you're trusting you to use good judgments with divided funds between you and your brothers and sisters. But my brother remains with you. Like, come on, out of 6 kids, who mom and dad trust? Who does mom and dad trust? Huh? Who does mom and dad trust? What has he done for Mon Dukes over the years? We first starting out. What has he done for Mon Dukes? How's he been a pillar of his family and his community? You already like don't in dire need, helping out. Didn't smack him over the head to be greedy. Understood the situation. But these gurus, they'll milk you for every dime. Gave a major discount because I understood the situation. Because I'm not thirsty. I'm not desperate. Understood the situation. Going through a lot of things right now. Had compassion. Sympathize with them. And it's my right when I want to show compassion, humility. That's within my right. So many of you changed my life. You changed my mindset. You changed the way I thought. So many. What Miss Stone say? She is a pillar, not in her family. You know when the old heads, the old people in the family get to talking about a certain situation in the families and family meetings and stuff. It be the aunts and the uncles and all that stuff there. You know what I'm saying? You know, I'm invited to those meetings. I get the Zoom link. All my grandmother, uncle, I'm the only one of the child that's sitting in on those meetings. But there you go. There you go right there. All you do is get the link, replay link, master, tap into the knowledge that shifted the entire room, but can't show you. You got the knowledge right. But behind the scenes, this is what you're really doing. But you got the knowledge, right? You got the knowledge. You got the knowledge. Oh, shift the rum. And then I'm like, yo, why is it that got all this knowledge, got all these degrees, but when it comes down to court, now it makes sense. Now it makes sense. As a matter of fact, let's say she owned that house, right? Damn, Kenyana, the house is worth $2,150,000 today. It is a beautiful home, Kenyana. You damn sure got taste. Oh, you got taste. Oh, you got taste, girl. And one thing I know, you damn sure know how to pick one out now. But it goes back to, look, she got taste, right? Basketball court in the gym, big old gym. Just would have loved to have that. You would love to have that. Hold on. Screen not sharing? I'ma share it. Hold on. You would love to have that. Oh, okay, let me remove this. You would love to have that. Look at that. You know how to pick out a house, girl. Woo-wee. Beautiful home. Masterful home. Look at the pillars. Hey, Kenyana Stone, there ain't one single process in the world that's going to get you that. You got to work for that. You earn that. It's not given to you. You got to earn that, girl. And you're not going to earn that through a process. Nah, blood, sweat, tears. You got to earn that 2.1. There ain't no secret trust. There ain't no secret account. There is no instrument that you can tender. There's no instrument that you can tender. Hold on. You ain't going to get it with that. Now you got to earn that. And this is what I mean with the processes that they do. It's all hopes and dreams. It's all being used to acquire the things that they know they don't have the capabilities or the capacity or the willingness to work towards that in real life. Now that right there will be a hell of a goal, a dream for people. That will be a hell of a goal and dream to work yourself up to get that one day. And I'm no millionaire by any stretch of the imagination. But if you really think in the United States of America that you're going to tender an instrument or a document or a process to be able to allow you to get this, when you deal with real estate transactions, they want cash money. And this is what these processes get people to do, thinking they can take shortcuts in life. They can cut the line. Thinking they don't have to work for nothing, all because that they think that they're entitled to something just because you were born. They think that. My bad, y'all. Man, these motherfuckers still working. Cold as a bitch out there. Come on, girl. I know this is what you really want. And guess what? I'm not mad at you. That is a beautiful home. That's a beautiful home. And this is the mindset. Because this person really thought that she was going, at the time, it was like 1.7. It's up to 2.5. So if you legally would have purchased the home around that time, you would have had a nice little bit of equity in it. And let's not get it twisted. Somebody is going to buy that home. Somebody is going to buy that home. We're not going to act like somebody is not. But the fact that you think that you was actually going to cut the line, you actually thought that you was going to cut the line and was actually advocating to get that, the mere fact that you actually did a process, the mere fact that you actually did a process on that, it goes to show more of your mentality. That is the struggle, down and out, low hanging fruit mentality. No matter. And guess what? Even if you didn't have that home, no one's going to be upset with you over here. That's a $2 million home. And the only people that people are going to buy that with cash money. They're going to cash out for that. That's an estate. That's a life. That's an inheritance you leaving behind. I mean, by the time my parents get up out of here, I'm hoping the value's that much. But Kiana, that's the real you. That's the real you. You got to accept who you are. That's the real you. That's the real you right there, girl. Hope they can hear me. Can you hear me? Can you hear me? Screen share. That's the real you right there, girl. That's the real you. And we got to start embracing who we are. So you can work for these things. Be realistic with yourself. We got to start embracing who we are. We got to start just where I would love to be in that house. I know I'm not there yet. But it doesn't mean I'm going to do it the right way. Enjoy the journey. Enjoy the fact that you can look back one day and say, damn, I worked for this. I did it. But as of right now, you gotta this is where you're at. Everybody's at different spaces. Embrace these times. Because when you finally earn it and get it, it's going to mean so much more than you trying to issue a negotiable instrument and cut the line. It's going to mean so much more. But right now, this is where we're at. And it's no problem being where you at. The problem is you being so ashamed of where you're at right now that you have to lie about degrees that you have. Or if you got all those degrees, because the degrees that you said you had, those are all well-paying jobs. They ain't no, you damn sure have enough to pay the filing fee. But if this is where you at, there's nothing wrong with being a nail tech. You got 4 kids. These are the decisions you made. You want food stamps? Hey, it is what it is. Need some assistance. But own it. But own it. No. Yes, you got to have millions. So to buy that immaculate $2 million home, you at least got to be sitting on 20, 30 M's. That is a major investment. That is a major purchase. But own where we at. They know my story. The new coach of Empire, the team know my story. I told them about my humble beginnings. I told them where we had to choose between, we had the gas, water, electric. 2 out of the 3 is getting paid. We got to sacrifice one. I came from humble beginnings. I know what it feels like to have a lot of money at one time. And I know what it feels like to be dead, broke, sleeping on your mom's couch. I know what it feels like because I was there before. But nothing didn't change in my life until I went out and did the work and changed it. My life didn't change through a process. It didn't change through a template. It changed because I put the work in. It changed because I made the changes. I put the work in. It's not going to change by acting like this isn't where you're actually at. So if you're selling these classes just to get by, there is nothing wrong with just saying that. Hell, they'll be more inclined to help because they get the situation. And it'll be a plus if there was anything actually valuable in what you're selling. Because now it's justified you charging the rates that you're charging. But it's not justified you charging the rates that you're charging when you're doing stuff like this. You're doing stuff like this. You got stuff like this going on. You got the fraudulent instrument, $1.7 million instrument you tendered. You're just in another group complaining about how hard it is. I don't really got it down pat, but yet you are a master securitizer. Like, come on now. Come on. It just doesn't, like, come on. You go from student to teacher, and it's not surprising because this is what most of them do. They want the allure in the spotlight of being a teacher, but they don't want the responsibility that comes with it. So they will be a fucking student in one group, and as long as you are in another group where nobody can see you or know you, then you turn into a teacher. They'll do that. They'll learn something brand new from someone and then go back to regurgitating what they just heard. Then they go back to regurgitating what they just heard. They go back to regurgitating to what they just heard. Like the last ones that tried me. Stick it together.
But can we go out?
Yeah, I gotta get some money, man. I'm broke. I'm broke, babe.
Don't play with me.
This paper, man, broke, man.
And I want to go shopping.
This paper, man, broke. Broke as a joke right now, man.
No, for real, babe. I want to go out tonight.
I got bills to pay. You know what I'm saying? I'm broke as a motherfucker.
That was not the answer I was looking for, babe.
Broke as a motherfucker, man. You know, money sticking together and shit. Shit crazy.
You don't show off. Check you out. No, for real though, babe. I want to go out tonight.
I got you, babe. I got you, babe. I got you. Hold
Okay.
on. Hold on.
All right.
Get all this in order. Let me get all this.
What we doing?
Let's get all this in order. Let's get all this in order. Let's get all this in order. Let's get all this in order.
That's mine right there.
Order right here.
Can I get that?
Fresh out of Navy Federal. They made me wait to the end of the line. It's the last person that tried to told him stop playing with me. I don't even do that no more because I ain't really got nothing to prove to nobody. Only thing I got to only people I got shit to prove to is my clients and the people that's in my group with the information and all the relevant information that we have. That's going to put them in a position to be the kings and queens of their own domains. But this shit was funny though. This shit was funny. I ain't gonna hold you. That shit was funny. That shit was funny. I ain't gonna. That shit was funny as hell. That shit was funny as hell. But nah, hold on. We ain't done. See, let me get sidetracked. We not done. We are not done. Because one thing that I do realize is when you are teaching things, when you are teaching things that have already been labeled sovereign citizen, and then you try to jump and switch over new to something new, one thing about it, your digital footprint follows you. Now, I just want to know this. Do you think in that securitization class that Miss Kenyatta Stone actually knew how many players are in the game? How many players are involved in a single securitization? Do you think she went down all the relevant players? Do you think she went down all the relevant players? Do you think that was a remote possibility? Huh? Do y'all want to know why the dream of a secret trust fund account would never come true if you were chasing that? Do y'all want to hear me say it, or do y'all want to hear directly from the horse's mouth? Hey, that shit was funny as hell. Do y'all want to hear directly from the horse's mouth? All right, man. I'm going to let y'all hear from the horse's mouth. God damn it. I'm going to let y'all hear from the horse's mouth. Fuck it. Why not? Why not? Let's just hear from the horse's mouth. Why any process that's related to a social security account, birth certificate, you'll be looking like Miss Stone sending fake checks in. Now, it may be hard to read, which I understand, but I'll read. We have received your multiple special forms of requests for payment of securities FS Form 1522. However, we did not receive any bonds accompanying this form, such as the Treasury bond. The serial numbers provided on the form are not valid United States saving bonds numbers. If you are suggesting that you are entitled to funds through your social security number or birth certificate, then you have been misinformed. Your birth certificate and social security cards are not securities, and therefore there are no government funds to which you are entitled because you possess these documents. This is a birthright / sovereign citizen scam, and continue to pursue this in any way can lead to fraud charges. For more information on this type of fraud, please visit our website at www.treasurydirect.gov / I can't read that word, fraud, birth certificate bonds. We are unable to assist you concerning this matter and consider your request closed. No further action will be taken. If we receive further correspondence from you concerning these types of fraudulent securities, we will refer the matter to the Treasury Office of Inspector General. Sincerely, Treasury Services. Now, how many people are going to hear that and instantly their whole hopes and dreams in the future, them already spending the money in their head, went down the drain? So now they either got to leave or plug their ears because they've already got their head set up. In a couple years they'll be 100 millionaires, so they never really established a real plan for the future because they thought this was going to come through one day, so they stopped planning for the future from a realistic reality standpoint. How many people in that split second are actually shocked and are mad and upset at me? How many people do you think are upset at me now? How many people do you think are upset at me now for crushing their dreams? How many people do you think have wasted time, years, and energy pursuing this, hoping that one day it will come through, just for me to come and go straight from the people's mouths who are responsible for processing such claims? Like, how many of those people you think are going to be mad at me? So, Ms. Stone, did you break this down in your securitization? I mean, we go over all this in my group. I'm pretty sure you knew this. All these different players, all these nuances, all this. I'm pretty sure you gave a thorough breakdown of this right here. I'm pretty sure you did in your securitization class. I'm pretty sure you did. Conduit administrators, A, B, C, D, the investors, the agent bank, the conduit, the BRE, the purchase, the additional asset security protection, the DPP, the conduit and the services provided, the liquidity facilities, the credit enhancement facilities, the conduit owner, like the nominal dividends, the fees going this way, beneficial ownership of assets going this way, deferred purchase price going this way, this going this way, this going this way, all the nuances and moving parts that involve in securitization. I know you didn't just cite one of the accounting statutes and then try to chart standing and change the title behind that. I know you didn't do that in your video. I know you didn't do that in your video. I know in your securitization video, you got the whole fucking breakdown and you're cross-referencing at least 7 to 8 different accounting mandates. I know you did. Girl, don't you tell me you didn't. I know you did. I know you did. I know you did, Miss Stone. Don't act like you didn't. You better have. Because if you didn't, just like this, denied. That's all your accounting stuff is going to be, is denied. You see that? Denied. Order on fee waiver. This is not the man that wished to file a new cause of action. This action was resolved. Denied. Why are you always trying to get out of paying something? Like, do you, like, your brain has been so warped of not paying for something because there's a secret trust that you don't even, you live your life. You actually, and this is the sad part, you actually live your life like you don't have to pay for nothing. Is that what you're teaching your students? That they don't have to pay for nothing? It's already prepaid? Well, we just read it from the Bureau of Fiscal Service. You're not entitled to any government funds just because you have a birth certificate and social security number. What if that was their original foundation and we stripped that foundation away? What do people have now? When you can't go into court and raise that argument. When you go into court and you can't put that on your documents, or you can't use that as a basis for filing tax returns, or you can't use that for a basis of nothing, where do you go to now? Where do you go to now? Where do you go to now? And this is the difference between her and having people in the group that is connected to the top professionals in this field in the world and runs and fact checks the information that you're putting out daily. Because if Troy was fact checking people like Kenyana Stone, the lawyers and them top people would have been came back and said that's fraudulent, and Troy would have been put them on blast. See, y'all think everybody's in the group is stupid and don't know as much as you, but let's say you had someone like Troy in my group that knows the ex-SEC attorney, knows the top CPA for 25 years, knows the top professionals in the same securitization and accounting that you're teaching, and it's just running back to the group. Can you imagine him being in Kenyana Stone's group and he said, that's not accurate. I talked to my attorney friend and he's been an ex-SEC, he's been an SEC attorney for 27 years, number 2 or 3 on the totem pole for the Morgan family. And he said that is not how it goes. Can you imagine the gaslighting that would have took place? And yes, it do. Not because they're defending and standing on it. It's because they don't want to lose potential money from the people that's listening.
To say one thing, there is very little people that I have utmost respect for, and I'm not saying this to brownie point or anything because it makes no difference to me. I'm that cut and dry. Lamont is only one of maybe a handful of people, 5 people that I have the utmost respect for what comes out of his mouth. And you got a great teacher.
That's the fact checker. I better not say anything inaccurate in my group. I better not say anything inaccurate in my group. I better not say anything inaccurate in my group. If I say it starts off as a promissory note and then it's not a promissory note, it takes on 3 different forms and names governed by 3 separate accounting rules as it moves through the securitization process. Then we get to the balance sheets and the line items, and this how much you're paying. No, you're not paying. It says this on the TILA disclosure. No, that's not the finance charge. The finance charge consists of this. They got to account for it over here. It consists for that. This is why you're overpaying, because there's an account for it over here. This is your finance charge consists of this. Number 3, they got to account for it over here. Number 4, they got to account over here. Now, this is what they do with portion of the funds. They do this, they break it down, percent it to the pool amount, then they go over here, they go over there. I better be on point. I better be on point.
You're rocking with the best.
I better be on point. See, that's the difference between me and people like her. Most people don't have a clue, so they can't call her out when she's making accurate statements, just like I was in her live. And then not only did I call her out on her inaccurate statements, I showed her proof of her own court case. Remember, she said, I don't got to show people my court case. Why not?
As a commitment to customer service, this call may be monitored or recorded. If you are a dealer or a
So
financial
we are
institution, please press
out
1.
of court.
We have
The
automatically
lawsuit
found your
has been
account. To
filed.
verify your identity, please enter the last 4 digits of your social security number. Thank you. Your identity has now been verified. All representatives are still busy. Please hold while your call is being transferred to the next available representative.
Credit Acceptance Compliance Team, this is Caprice. How may I help you?
Yes, I'm calling about GLE 350. I informed credit acceptance of the pending lawsuit that I actually have what on my way to file now. So I don't want to talk about anything legal. I just want to see what the remaining balance, because I was actually trying to print off the payment history, as far as my attachments for, for the judge to see. And I'm not able to print off my payment history or the payments I made. And I was also trying to get the remaining balance feature for the print off as well. But I'm unable to see the remaining balance. It says NA. So those are the only questions I have. Just the remaining balance in NA status, the payoff history, payment information unavailable. So I'm just trying to see if what's the reason behind that, because I did send a detailed email to operations, and it seems like since Saturday I'm being routed to compliance and not just speaking to the regular representative, which is okay. So those it. You could provide it for me. That'd
Okay.
be good.
So who am I speaking with?
Lamont Thomas.
All right. And Mr. Thomas, just for security on the account, can
Yeah.
I have your date of birth and the zip code we have on file? All right. Is that
Yes.
still the best number, or do you want to update that?
No, that's the best number.
All right. Thank you so much for that information. And let's see here. The reason that you're not able to access the information through our customer portal is because of the email that we
Right.
or letter that we
Right.
received
Right.
from you.
Right.
That was actually escalated to our compliance team. So whenever we have, an issue where we're
Right.
investigating something, we place everything on hold.
Okay. All right. Okay.
Okay.
Cool.
So what I can do is I can actually email you a copy of your payment history if that's what you are
Yeah,
looking
yeah, that's
for.
cool. Yeah, just the payment history. That's perfect. That's perfect. That's cool.
Okay. Give me just one moment here.
All
Let me
right.
get that up here.
All right.
Okay, I'm almost wasted, and my drip is on the spaceship. One more sip, yes, I can taste it. Come to my.
So when I say your debt validation letters, when they respond to them right back to you, that means it didn't meet the requirements for it to be escalated. When they're like, hey, we have a problem here. So when I say that because I know what I'm talking about. I don't say that just to say that. And all along, when y'all sending these debt validation letters to them and they respond back with some BS, and then you respond back like, hold on, this still ain't true. And some time goes by and you don't see any action, anything moving on the account, they'll still be hitting the credit reporting agencies. But this is from accounting. Can you just imagine if Kiana Stone had those emails? Can you imagine the documents, the accounting, how I took all their regulatory filings, broke it down, applied it to a consumer? How do I take highly complex accounting, securities laws, investor laws, corporate finance structures, and then apply it to a consumer. Apply it to the consumer. How is that how is that possible? Well, number one, deep research and understanding, years at this. And number two, what if you really have professionals on your team? What if you really have professionals on your team that's going to nudge you some information that you kind of got to be on the inside to know? Doesn't that give us an advantage? Doesn't that, hey, nah, they do this behind the scenes and they move it this way. So now ask exactly for this. I guarantee they're not going to want to provide it. Or what if you have their whole internal model on how they do your whole transaction? Like, what if you have their whole cheat sheet? Huh? Like, let's say I'm a finance company and I use a model and that jacks up the price, that does all this, but it actually shows the amounts that's you're really paying to get the contract, but it shows the amounts where they jacked up the interest rates and all that, where they inputted. What if you showed them that? What if you showed them that, oh, by the way, what if you showed them the amounts that is disclosed as paid on TILA is nowhere near the amounts that they are calculating that you owe? What if you, and think about it, all I have to do is look at page 2 on the TILA disclosure. That's all I got to do is look at page 2 on a TILA disclosure, and that's all I need. That's all I got to do is look at page 2 of the TILA disclosure, find out who you got your finance company with, and that's it. See how many years it took to make the process now? Just like that. That's all it takes. That's all it takes. That's all it takes is page 2 of the TILA disclosure. That's all it takes. Let me show you what I'm talking about, what it takes. This is all it takes for me. While these gurus gonna be running around every type of rabbit hole, trying this, trying that. We don't need to do all that now. This is all it takes. This is all I need now. Bam. Let me save this. This is all I need now. This is all I need now. Huh? It's all I need now. Any contract. I don't give a damn who you with. We done got so ice cold with it. I wouldn't even give a damn if you were with a credit union. And they don't offer securities to the general public. I wouldn't give a damn because they do everything internally. Oh, y'all don't remember when I had that confirmed just by being on the phone and letting the lady talk with Navy Federal? Oh, y'all ain't know that? See? And guess what happened a few weeks later? Mortgages are sold internally. You want to know where they got that from? They got that from watching your teacher's video. A lot of y'all teachers watch my videos to get information to go back and teach y'all. It's all it takes right here. All it takes. It's all it takes. Let's go number 4. It's all it takes, from 4 down to 7. It's always going to have an amount, total charge, amounts paid to others on your behalf. You notice how it's always going to be a low number. But then you go to number 7, amount finance, unpaid balance. You see the difference between that is $18,573.71. That $18,000 is not broken down here. But guess what? With the courts and them, you actually got to know where that $18,000 went. See, you can't just be like, oh, it doesn't disclose this, so it nah. Where did the $18,000 go? See, I told these people, yeah, it shows only $4,190.75. But it's $18,573.70, I think 71 and 77 cents missing. As a matter of fact, this is where it really went. Oh, matter of fact, instead of me telling you, I'm gonna let you tell it. Exhibit. So now I'm taking what you're really charging as a finance charge. Now I'm using that to argue TILA. Makes that TILA hits different now when it's like, Your Honor, the amounts that they stated as finance charge is not broken down in the itemization of the amount finance, because the amounts finance are not, the real amounts finance are not listed in the itemization. On the contract, it only says taxes, dealer, business tax, CVR, electronic filing fee. But it really says it right here. This is what I'm really paying in finance charge. And none of this has anything to do with me. As a matter of fact, Your Honor, they've already said that their accounting is never accounted for alone to me. As a matter of fact, Your Honor, I'm going to let them say it themselves. Exhibit. And this goes to show that, well, I can't really get into too much more because I'll be, But you see, all I got to do is just look at anyone's contract. And I'm going to go right the last 3 lines. Okay, I got the real finance charge. Do you really actually know how long it takes to be able to just pinpoint that? See, the difference between me is I make sure I have a full understanding before I start teaching it, while the teachers, they'll start teaching it just because it's something new to make money while they're still trying to grasp it themselves. But if Miss Stone was so much of a guru in accounting, why couldn't she get to the point where they're not repossessing her vehicle? Why couldn't she get to the point where they just stop collecting? No payment history, no account balance due. Everything is just bam, stop dead in its tracks. If she was so much of a guru, why, when the lawyer responds, they don't want to talk about it no more? Why would the lawyer respectfully declines? Why are you declining now? You don't want to talk anymore? See, that's called real accounting, not this. This is your teachers. This is your teachers right here. This is what they're going to tell you to do. See, that's the quick way. That's the easy way. It doesn't take much thought and effort. Make it payable to the treasury. Bam, bam, bam. See, this is all, look, that's all you really have to know. Either get their bank's account number, locate the Federal Reserve number that's associated with the number on your back of the Social Security card, write payable to the United States Treasury, send it in and wait for money. See, 99% of people would take that route because it doesn't require comprehensive thinking. It doesn't require time. It doesn't require patience. And as humans, we are impatient because nobody was ever thinking about this stuff until somebody said it was something that they can acquire and they don't need to have any skin in the game. Free. There is no difference between the mindsets of people who are on government assistance, who rely on it, who are overly dependent on it in this process and stuff like this. What is the major difference? Because we've already satisfied from relevant authority that there's no account number with that name on it just by the sole purpose we got a birth certificate and social security number. There's no treasury account. And let's just say that was true for the sake of, I'm not saying it's true, but let's just say that was true. Why not go straight to the treasury yourself and get the money first and then take the money to the real estate title company? Why not just do that first? Wouldn't it make easier? Let me go grab the money from the treasury first. I'll be back to see y'all. But the reason why they don't want to do it that way is because someone told them that, let me share my screen. Someone told them that just because you have a social security number, birth certificate number, you don't have to work for earn anything anymore. This is going to fall right at your laps. This is going to fall right at your feet. You don't need, hey, guess what? You ain't got to do nothing to get it. Matter of fact, let me go back and yeah. This is going to fall right at your feet. You don't have to do nothing to get it. Look, you don't have to do nothing to get it. Just issue an instrument and you can have this. Do you see that they are so desperate to get out their immediate situation that they don't even realize like just how does it really look? Look, family room. Now, the girl got good taste. Immaculate home. Now, look, this is the date that it was sold. Now, let's go down here. This is let me go here. This is when pending sale. This around, so let's get back to July. This is when she started to put in to buy it, June 21st, 2023. And then they changed the price. So around this time, from June 21st to July 29th, the price, the transaction was canceled July 10th. This was Kiana Stone, pending sale. She came to him like, all right, I've been studying for years. I'm ready to go. I know how to do it now. I'm ready. I can issue the instrument and buy this. And then they changed the price. And then the price changed again back here. And this is when someone who actually had the money came. And now you see from this date to this date, this when they were in court. This is when she filed the fraudulent UCC-1. So after they got the summary judgment against Kiana Stone, the sale went through. The owner held the house for 2 years, realized the property value is going to increase, get a $700,000-$800,000 out the deal. That's a gain. Now they're going to have to pay taxes on that unless they put that $800,000 into a like-kind property. That's the 1031 like-kind exchange. So they don't have to pay property. And if they do that within 6 months, they don't have to pay taxes on that $800,000 gain. But that's a totally another different story. So now the new owner is listening for sale. So when Kiana was on her live saying that the case is still going on, it's in the Supreme Court, how can your case still be going on in the Supreme Court when it's been sold since December 8th, 2023? And obviously you wasn't in the home, because what more would you use as a marketing? And I agree. If she would have gotten that home, she'd have been every goddamn within her rights to sell that for 50 to 100,000. Matter of fact, she'd be lowballing herself if she didn't charge 100,000 cash money up front. You see? See? So when the comment was made that she got people online slandering my name, there can be no slander on my end. There can be no slander on my end when all I'm doing is just speaking the truth about her processes. Public record. This is the truth. See, we can get to smear campaigns and all that, but the reality of the situation is that this is what it is. This is the reality. She had these dreams. She had this type of dream, right? She had this type of dream, but had this type of means. You see, when reality meets dream, see, that's a dream. But this is reality. This is reality. This is the reality. Okay? This is the reality. This is the vehicle that got repossessed. Look, this is what got the vehicle repossessed. But she's teaching an accounting class. You see what I'm saying? And the other one I showed, the letter of instructions, that was her trying to pay a bill. You get what I'm saying? And you know what's even crazy? Let me show you what's even more crazy. I mean, this is all you got to do. Bam. 179 comments. Look. This is her digital footprint. And this was just 90 days ago. So how do you become such a, look, cash, credit, look, click coupons from municipal coupon equals credit. See, all that is when you need something to be so true so much. If you need something that you don't have to put energy in to substitute for money and use that, this is when you start to become biased even in your own research. It's called confirmation bias. You're not really studying to learn. You're really studying to try to confirm what you believe is true. But this is all you really have to put. And then look. Chase Auto on demand. Now look at this. Let me see if I can blow it up. Y'all can see it. We haven't received the payment, and she puts tender. You see the semantics games that they play? People in these communities play the semantics game because they know what they're really doing is wrong and not legit. So playing semantics, payment, tender, is just a way for them to tell themselves what they're doing is right because their higher self is convicting them knowing what they're doing is wrong. You see that? At this time, you owe $855.98. Now let's ask yourself a question. Let's ask yourself this question. Do you think with her owing $855.98 in 2023, if your payment is on the way, thank you, your account is not delinquent and the late fee has been assessed in the amount of $16? The fees or charges resulting from this past due that were not included in the total due above will be reflected on your next statement. You see this? Now, do you look, that's why she did it. Now, do you think that vehicle was not repossessed? I mean, let's go back and look at where we're really at now. Let's go back to where we're really at. Look, stamp duty tax paid. She's talking about a stamp tax act from the 1800s that's not applicable in finance transactions today. See the mix matching of the product. Look, now your taxes. Now this. Late charges, $33. Payment due date. Contract date. So it took about the timelines when you start to see people who started out normal and then they start to do this when they've already made payments on the account. You want to know what that means? They've fallen on hard times. And that's all what this was with Kenyatta. She fell on hard times and she has to do something. I get people that reach out in these same situations all the time. They fallen on hard times. They were desperate and they had to do something to keep their mode of transportation. And then bam. But she's online saying, everybody do this too. I don't want to be the only one. I don't want to be the only one looking stupid. Everybody, I need y'all to do this with me. Everybody do this with me. Look, I even got my own version. Whoop, whoop. I need everybody to do this with me. I don't want to be the only one looking stupid. I don't want to be the only one looking stupid. How many variations of these processes have we seen? So you get a $1 money order, which there is a serial number that's going to trace back to the $1 money order. So they think that, oh, any disputed amounts versus the written amount is going to be taken is true. Right? But it's something called unauthorized alterations. So do you think Kenyatta Stone is going to be able to dispute that by showing that she paid $25,098? Do you really think she'll be able to get around that? And this is what they have y'all doing. Processes that are fraudulent, processes that teach you how to be disingenuous, process that confirms your greedy intent, confirms that you don't want to be accountable, confirms that you want to get things on your face, but you don't want to pay for it. If you don't want to pay for it over time, then why don't you just buy it outright? Oh, because the funds are missing to do so. So these are what I call struggle processes. These are not real classes and teachers to give you understanding to attack the system from the highest level. This is all struggle, pay a bill process. Everything is being done. It's not to learn. It's not to gain understanding. It's just to pay a bill. This is why I call them the low hanging fruit, because only the low hanging fruit will ever be a part of or try things of this nature. And if you were low hanging fruit before and you wised up and got out the low hanging fruit mentality, shout out to you. But it just goes to show why it's very important to vet the people who you're giving your money to. What she got? Navy Federal. She got a Navy Federal situation. Accusing them of unauthorized electronic funds transfer. So it looks like the case is still going on. Uh-oh. Oh.
Hey, shooting positivity out there for y'all today, man. Be the cleanest at you. Time to get to work, get some things done. Hope y'all getting something positive done today. Hey, people out there in TikTok land, what's going on? Hey, shooting positivity out there for y'all today, man. Be the cleanest.
Well, I thought I had something. What did it say? In other news, I won my case with Navy Federal. Huh. Well, if they took unauthorized money from her, yeah, that's cool. I mean, it's nothing. I mean, if they took money they weren't supposed to take, I mean, anybody can win that. But let me see. She says she won. Is that Kenyatta Stone? It says it right here. Hell yeah, Kenyatta Stone. In other news, I won my case with Navy Federal. Yeah. Okay. God damn. Always finding the leave to not pay that goddamn affidavit. Oh, I can imagine what was on this affidavit. I think I got Pacer. I'll go on Pacer and get her affidavit. Get her in Papra. It looks like the case is still ongoing. Let me see. Because she says she won her case with Navy Federal, according to that post. But when you I don't know, because it looks like the case is still open. It looks like the case is still open. So there we go again. You see what I'm saying? You didn't get the win yet. You didn't get the win yet. Let's see. Well, that's it. So I don't know where this win she's talking about because it would have been updated. And last updated October 13th. And Navy Federal responded. I got paster.gov. I'm not paying y'all. So this is another thing that I'm saying. If she won her case, cool, she won her case. But there's no evidence as of right now. The case looks like it's still ongoing. It looks like it's still ongoing. And it hasn't been updated since October 13th. So if she's running around saying she won her case, that's it keeps going back to this. So this looks like it was from Facebook, but what's his name? B. Givens. Oh shit. What's his name? B. Givens. Let's do a little investigation. Shit. See, I don't even know now. Yeah, I don't. B. Givens. That's the name. Let's see. Was it on this post? All right, let's do this. There we go. Oh, God. It all makes sense now. It all makes sense now. It all makes sense now. So let's go back. When were these comments made? I could just drop. I'll just scroll down for a little bit and see. And this is what I mean right here, y'all. This is what I mean. This is what I mean. What is double bookkeeping? This is what I mean. This is what I mean. This is what I mean. Vague recitations, no deep breakdown. You're never going to get the full understanding. That's just all it is. Look, perfect, like all. Look, UCC 1. Elliot. Is this that guy, Elliot? It is Elliot Dwayne Bruce. Looks like him. My UCC 1s are lawful. Right. Sure they are. Let me see if your UCC 1 is lawful or not. Let's see. Yeah, I couldn't. What the hell? I thought I was sharing my damn screen. Ain't that a bitch? I should have said something. Let's see. What is it? Elliot Bruce Royal Association. And who's the debtor? Elliot Dwayne Bruce. And who's the secure additional debtor? Who's the secure party? Bruce Royal Association, private ecclesiastical government. Oh, God. They ain't even know we didn't even talk more. private, ecclesiastic. Where does that come from, y'all? Look, took all this shit down. Look, he took all this shit down. Yeah, he took all this shit down. UCC, like sovereign. When you walk, do not use creditor language. It's time to take all this shit down, ain't it? Took all that shit down. Look, took it all down. Look, taking it all down. I told you, when that shit comes back and bites them in the ass and they no longer can explain their way out of it, what do? They start taking their content down, acting like, now look at this. Difference between SSN with dashes versus SSN without dashes. Abatement, motion dismissed, lack of jurisdiction. Look at all this shit. And this is the sad part, man, that everybody is so fucking money hungry, thirsty for a quick buck, that they don't. Courtroom procedure 101. Read this before you step into any court. Well, what if the courts have their own set of rules? Special appearance is a motion to dismiss. You see what I'm saying? Special. My God. Look, all the, and this is what I'm saying, y'all. People will always have a hard time with what I'm saying. It's because it's not comporting to their foundation and what they first started learning when they came to this space. That's all it is. It's not the information, not the receipts. It's because they think different. This is not my way, my method. My way comports with the economic reality of the system. And you can only measure that based on the responses that you get, based on the tone, based on everything shifts, credit acceptance, case filings, me filing cases for my clients and their cases not getting thrown out. So you can start to measure and you get what I'm saying? You can start to see, but look. I'm trying to see where this comment was, where, by the way, I won my Navy federal case. And all they do is just throw statues out there to you, something that's enticing. No allonge indeed, trust arts, like they, it don't matter. You have to know how to argue it in court. I have witnessed it with my own eyes. Third-party remedies do not apply over here. And another thing, people have gotten so used to not life estate. Yeah. They have gotten so used to not proving everything they say beyond a reasonable doubt and showing black and white, that when people actually come with receipts, it's like people hate that more than the person that's talking, because they don't want to really see people with receipts that's different from what they believe, because it has a psychological effect that makes the person think that, well, maybe what I've been doing is wrong. But since I spent so much time, money, and energy in it, I don't want to feel like I got scammed. I was wrong. So they will double down just so they won't have to feel like they got scammed. And that's all what it really is. Nope, that ain't it. I'm trying to see. What was it, September? We should be getting down to it. But a lot of this stuff was taken down. As y'all can see, he took a lot of his stuff down. As you can see, he took a lot of this stuff down. Leave a little bit of stuff up. Like little stuff like that. He'll leave a little bit. Look at this. Look, American State National. No matter how many times the government in the state says that's not a valid ID, they will still force it. Like, people move off what they believe is true rather than following the rules. And then want to complain when things don't go their way. Look, all this content taken down. But I'm trying to see, where was this? Could it be here? Nope. Because to most of them, they actually think it's competition. And to be honest with you, there is no competition. It's no, why would I be in competition with people who has no professionals on their team? Who has no professionals on their team? Who has no top elite professionals on their team? Why would I be in competition with people who are spewing based on what someone told them in their false sense of understanding? The things that I know and the things that we cover in the group, the average person doesn't even know exist. So why would there ever be any sense of competition on my end? Professionals call my phone, clients still lining up, people sending me emails about the Supreme Elite Team University daily. There is no sense of doing this in a competition, none of that, because there is none.
Keep putting in that work. Keep putting in that work. You know why? You almost there. You almost there. It's gonna pay off. It's gonna pay off. And they don't want you to know that. They don't want to give you that inspiration.
I be struggling to get it because it's so hard. I know. I know. I know. Supreme Elite Team University. Yes, sir. I feel like it's going to be a lot of professionals in that group, more of the professional than just the average everyday person, because it might be too much for them to grasp and understand. We were ordered to respond. We responded with a motion to dismiss. The judge over. Oh, yeah, I remember that. See, look. One like, one comment. Do you actually think do you actually think what a lot of people, most people crave for every day? I told you, y'all, this space is filled with a lot of haters. They don't ever want to see you with a remedy when they don't have one. They don't ever want to see you with it's not about learning the right way. Most people, when they see other people who has the ability to get results, they immediately start envying and hating. This should have had 5,000 likes, 400 comments, but since it's receipts and they know they haven't got one with their teacher, it's kind of like they're mad at me because their teacher couldn't get them over the hump. So it's like they take it out on me. 1 second. Enjoy.
Okay, so it looks like on our side we do not hold a copy of the deed or the title. You would need to get in contact with the county.
Okay, well, it was released, satisfied. So the county will actually have
the deed to the home?
Correct. We do not hold a copy of that. You would have to get in contact with the county.
Okay, what is this showing up on her mortgage account?
What's that?
What is anything show? Is it?
I haven't even pulled that side. Give me just a moment. That's just interline.
Oh, okay. Oh, yes, ma'am.
Okay, it looks like the balance is 0.
Okay. All right.
Okay, it looks like the balance is 0. Okay, it looks like the balance is 0. Okay, it looks like the balance is 0. Okay, it looks like the balance is 0.
I don't even need to say more. I don't even. What else to say after that? What else? All I asked was if I could send a mortgage application paper instead of doing it online. But that's the only thing you really need to hear.
You're rocking with the best.
You know, that's what I'm saying. And people, I'm telling you, y'all, people do not want to see you with any results, any remedy if they don't have it. Like a lot of people that I'm telling you. I'm telling you. Now let's get to let's get to well, I can't really get damn. Yeah, let's see if we can get to that. But that's what it is, man. They don't really want to see you with anything, bro. They don't really want to see you, bro. Yeah, it's so many fucking haters. Yo, the teachers are the boy, they hate so much. I get on their panels and I destroy them using their own arguments. And I'm telling you, they can't stand me. Want to know why? Because let me see. Not knowing single-handedly if I beat them, credit acceptance, that's going to change how consumer contract. Everybody that has a consumer auto loan is going to benefit from my case in the world. Primary implication would be the intent of validation of original loan comment, the entire consumer loan could be deemed invalid, including the agreed upon interest rate and any arbitration clause. The transaction will fall under purview of security laws instead of consumer credit laws. The standard of liability for misrepresentation or omission in securities is generally stricter for that than in common law fraud and loan agreements. Mr. Thomas could be entitled to the different forms of relief, potentially return of all payments made, recalculation of his obligations based on the new legal characterization. These are some of the things, these are some of the potential outcomes if the judge sees it my way. The judge sees it my way. A court ruling characterized consumer laws and security will have disruptive and far-reaching impact on CAC's business model and the broader auto finance industry. CAC business model becomes subject to extensive federal and state securities laws, will necessitate significant operational changes, increased compliance costs, and potential registration requirements for loans. CAC could face a higher standard of liability for disclosures, potentially open them up to a new wave of litigation from other consumers under securities law. I would set the wave. I beat credit acceptance. Do you know how many goddamn lawyers and advocacies are going to follow behind me? Are going to follow the Supreme Elite Team's wave?
You're rocking with the best.
Do you know how many consumers would be entitled to relief if I beat credit acceptance all over the world? Disruption of business. models. The current method in packaging and selling auto loans as asset-backed securities could be called into question. The recharacterization would challenge the fundamental premise that these underlying assets alone potentially disrupting the flow of capital, increasing borrowing costs for the company. If the judge sees them our way and they found some motion to dismiss, which is going to be very hard for them to get around, they're going to end up settling. Because if this goes to trial and I win in court, every single one of y'all that got a consumer will automatically reap the benefits of what I've done.
You're rocking with the best.
The lawyer was like, yo, the lawyer read my whole brief. The XSC, he read the whole brief. He said, there's no way this is going to trial. I mean, that's him. He don't. I mean, that's his opinion, but I'm prepared for trial. I got my jury instructions. I got my discovery requests already done. I got my counter. I got my cross-examination. I got all that done. Do you know this would fundamentally change how auto financing is done in America? It will change how it's done. No one has ever raised these type of claims from consumers. The only ones who've done it are attorney generals, and they didn't really get that in depth. It's only the attorney generals. No consumer has ever done it. It will fundamentally change how auto and financing is going to have far-reaching effects in mortgages too. It could systematically change the system as we know it today. They're not going to let that happen. They're not going to let that happen. The system is designed for the 1% who understands to win. Not everybody just because you ran across this online or in a group. The reality is all these people that are in these spaces, less than 1% are ever going to be successful. That's just, and it's not because of what you know, what you don't know. It's just because the system is what it is. The first wave always gets through. After the Supreme Elite teams wave, they would tighten the reins up and make it even more difficult. The first wave always gets through. And why you think we position ourselves for the first wave? Oh, you ain't got to worry about nobody ever making an argument that I've made. Oh, no. Hell no. Taking tax, accounting, security, securitization, highly complex accounting, highly complex securities law, case law, and making it all into one and still connecting it to the underlying claim. New culture empire team. Yeah, I don't have to worry about that. And even if it's a copycat, they would have discovery. He gave me a few that dealt deep into these topics. You do not have to worry about it. The new culture empire is going to be on that first. The old wave, they done already did this, redid their internal regulations, so they're going to find a way to stop it. The first wave, That's why we're going to be on that first wave. Sooner or later, everybody's going to be copying office. Sooner or later. That's just the nature of the beast. Sooner or later, everybody's going to be teaching straight from an accounting behind the scenes standpoint. Sooner or later. Because they're going to start to see so much results coming from out this group that they're not even going to have no choice but to try to get into the Supreme Elite University and then get done and sell that. But guess what? By the time the Supreme Elite Team University is done, we've already got our wave. I mean, we got stuff in courts now. We got stuff ready now. Why nobody really understands what's going on. The Supreme Elite Team, I mean, it's going to be closed confined. We're going to have all the measures, but you know, you're still going to have mixed in with a poverty mindset. People don't make to benefit and capitalize off things that they don't want to take their own time to do. So all they're going to do is convolute it, add the BS to it. And they go, oh, it didn't work. It didn't work for you. Oh, that accounting stuff, they'll never let you win. Oh, no, they're going to come take your vehicle. Someone was saying, I said, well, they may have taken yours. They took yours because you didn't know what you was doing. They didn't take mine. They didn't take mine. They didn't take mine. I haven't made it pay July. Hell, they haven't even sent me a payment due notice. Hell, the last notice they sent me was 15th. I sent that email to them August 18th. Ain't heard a word from them since. That's you. There's a difference. See, there's a difference between, there's the Supreme. That's just what it is. There's a Supreme Elite Team, and then there's, because the Supreme Elite Team are the only ones with verifiable, real law, real life, real professionals on our team. Everybody else says they have them. They say it. Or they say it, but you never see them. You never hear any phone calls with them. You never hear any of this. You never hear any of that. You never see this. You never see that. And I know the name of the ex-SEC attorney. I know exactly who he is. Come out the Morgan and Morgan family. I know exactly who he is. I know who the Morgan family is. I see the commercial come right out that family. Exactly. I'm never say his name live. I never say his name live. Know exactly who he is. We're the only ones with real professionals on our team, and we talking high level professional. All these other social media gurus, they have nothing. They don't have none of that. So for now, y'all, Supreme Elite Team, we're going to ride that first wave. We're going to get ours, get out the way, and sit back and watch the rest of them try to pick up, try to take what we took years to build and try to hurry up and do it fast because they see a new avenue to get a remedy. I don't see it, no real understanding. Okay, so let me just say this. Without someone that really understands and knows what's going on, that can go in the right direction so you don't got to spend years going down the wrong rabbit hole. If you would just start, it's going to take you at least 10 years to understand this system. 10 years over 10 hours. You're going to have to read at least over 250 court cases, thousands and thousands and thousands of pages of regulations and authoritative. You're going to have to read 568-page account, 500 days. You got to know how to read the balance sheet. You got to know the calculations. You got to know the discount federal standard rates. Then you got to read thousands of pages of regulations and the IRS and tie all that into. No, it's going to take about 10 years. If you're just doing it on your own, out about a good dime. That's how deep this knowledge goes and the understanding and the nuances. It's going to take you about a good. Motherfuckers can't even sit down 6 months when they get in this space. They being here for less than 30 days. They're already filing 1099s. Ain't even read the instructions to the form yet. That's based on human nature. Supreme Elite Team, we are protected. Leave your one before we go. This lawsuit against Credit Acceptance Corporation isn't just about one contract. It's about exposing a nationwide scheme that's been hiding in plain sight. This lawsuit against Credit Acceptance Corporation isn't just about one contract. But y'all get the picture. Y'all get the picture. Look like it don't want to cooperate. Y'all get the picture. Y'all get the picture. I get the picture. This lawsuit against Credit Acceptance Corporation This lawsuit against Credit Acceptance Corporation isn't just about one contract. It's about exposing a nationwide scheme that's been hiding in plain sight. Credit Acceptance structured my agreement to look like a simple car loan, but behind the scenes, they securitized it, retained control, and charged a 23.99% interest rate, well above Virginia's legal limit. That's not just deceptive, it's unlawful. And they're doing that in every state they operate in. If Virginia steps in this case, could trigger a wave of enforcement against lenders who use dealer advance programs to disguise true lending relationships. And if the federal government follows through, the IRS, CFPB, or SEC, then consumer lenders across the country will be forced to rethink how they structure, report, and enforce their contracts. This lawsuit demands restitution, recharacterization, and accountability. But more than that, it could set precedents, forcing leaders to respect substance over form and putting consumers back in control of their financial rights. The system's been rigged long enough. Now it is actually time to expose it accurately. And the claims that I'm raising in my lawsuit are the same claims that Credit Acceptance has settled numerous of times with investors, other consumers, or state attorney generals who actually stepped up and held them accountable. This lawsuit is the first lawsuit in the history of the Fourth Circuit and all other federal circuits where claims of this magnitude has been brought against Credit Acceptance Corporation or any other finance corporation from a consumer capacity. You normally see these lawsuits filed by attorney generals of states or the lawyers for the investors. Never have you seen these claims filed from a consumer standpoint. I've seen a lot of consumer complaints and lawsuits filed against Credit Acceptance and other finance companies, but they all have missed the mark because they are approaching it and attacking it from a consumer-like standpoint and doesn't have the mindset of a creditor or a lender to attack them on the level in which they operate. This lawsuit could actually spark a reform in consumer financing. I am one man taking on the complex system. So, let's go. It further goes to says that this is what took place, man. I signed the contract. The dealership transferred that contract to Credit Acceptance. Credit Acceptance now had the proper collateral so they can issue trust notes to the investors. The investors put the money up for my dealer for the purchase price in exchange for the contract in which where I will be making my monthly payments. Cool. No issue with that. The thing is, and your legal department admitted that Credit Acceptance never gave me any type of funding in order to even support a contract, which is not a big deal. Rather, they got my promise to pay the security and they was able to raise the funds for the purchase. So is it that credit, and this is their own words, I'm reading it from and it's filed with the SEC. So is it more that credit acceptance really just acted as a broker between me, the one that needed financing, and the ones who's willing to invest in my contract? So you all just kind of mainly were just the middleman to broker the deal instead of really being a lender in the traditional sense, like credit acceptors went into their own back pocket and put up the money. You kind of more brokered the transaction. Is that more of an accurate statement? Well, I'll be damned.
Reminiscing the good old days, remembering to forget all the bad ones. I remember when college seemed so important, but is it worth it? Been wondering what truly matters to me. I know for sure it's not a fancy degree. I'd like to do what I love. What if I'm not good enough? Split personality. Sometimes sour, sometimes sweet. And then my Shyamalan story called everything's peachy. Can we just skip straight to the plot twist, please?
Let's go! It's 3 months. I've been watching you like a hawk. I've been watching you like a hawk. I know how you work in and out, inside, outside.
Life's all about balance.
I know the measurements. I know the discount rates. I know the discount rates. I know the measurements. I know your caps model. I know what you tell them. I know all your level inputs. I know what trust it went into, which day it went into, the discount rate, 6.5% on this one. I know the difference between this and this is what you take back. I know all 5 different accounts that you hid the money in. I know the dealer holdbacks. I know the down payment. We are ready to go. And I don't even need a script. I can argue this case off the top of my head. 4 points. 4 major points, Your Honor. That's it. You got a 90-page complaint right there. Don't even worry about that. All I needed 10 minutes, Your Honor. And I'm going to put them all the way together. And every allegation I made, I could find an instance where they had to settle with the attorney generals. Didn't even want to talk about it. Didn't even want to talk about it. And every single case, every single argument I made, there's case law to support. There's top professionals saying it. There's the accounting rules to support it. There's, hell, you want to go to state law, federal, state case, federal case, bankruptcy case, IRS case, civil case, whatever case. I found multiple cases from multiple different venues. That's all confirming what I'm saying. I am fully prepared to argue this case in front of a federal judge. I am fully prepared. I know all the court rules regarding to it. I know the rules of evidence. I know the rules of procedure. I know the rules. I know the rules of rules of evidence. I know the rule. I know all of it. I know all the rules that go for it. I know the timing. I know the interrogatories. I know the admissions. I know the pleas. I know the discovery. I know how to compel discovery, subpoenas. The whole court rules regarding I can off the top. I'm ready to go. The question is credit acceptance. Are you going to be ready to go? Because you got 15 days left to respond. You got 15 days left. You got 15 days left. You got 15 days to either respond, admitting that you lied to the investors, or you got to confirm what I'm saying is true.
You got 15 days because those are only 2 things that you got. And it didn't meet the court's requirements because the judge screened it for 3 months. It took them 3 months. And the judge, see, they gave me that summons. You don't get to arbitrarily go get a summons. The court has to approve the summons. Because when I went to pick it up, she said, hold on, let me check with the judge first. And the judge says, yes, you can now serve them. Plaintiff's original complaint will be the operative complaint in this case. 3 pages of full scalpel. Now, you want to talk securitization? That's how you break down a securitization. Now, that's how you do it. And if you argue it any other way, go with any of these gurus, you're going to lose. Until the next time. New Culture Empire.
I'm cooking up dog food.
Streaming team.
Smoking that leaf from Toronto. They watching that wrist like a car show. You look like you want to get shit off your chest. I thought so. I'm back in this game now. You sit at the end of the bench. I thought so. Yeah, back in this motherfucker like I left something in this bitch. A whole gallon of the white. I'm getting drunker than a bitch. Big straps with the Mac 11s got me putting extenders in the clip. And leave your shit up on the curb. Like you didn't pay your rent. Got Papa John dope, but no pizza. The dope with a flipping straight O's in the zippers. Right off the Peter Pan, intake at 9 if you open this Millicent with you. My BBE label with guys on the table. Fuck your scar to your Dracos. This Mac make you jump, no Chris Carson is stable. You get scott like potatoes. Shorty saying that I am the one. Who the fuck you think she Billie Jean? She want a nigga, put her on the team. After spitting out my kiss, a Listerine. The flow is bucking like it's Greek the Freak. But I keep it 44 like Pistol Pete. I really shitting on your biggest dreams. Mouth the floor with you niggas, Mr. Clean. I'm cooking up dog food. She play with the dick with the tossers. I'm smoking that leaf from Toronto. They watching that whisk like a car show. You look like you want to get shit off your chest. I thought so. I'm back in this game now. You sit at the end of the bench. I'm in the projects like I'm packed with a cake. They ask about it, they say missing no plate. I know the smells when they pull out them trays. It's nothing edible that sits in the place. Right out of prison, I ain't snitching nobody. You ain't jumping lessons up on the base. I need some water so I can splash in the lake. And I need a rat so I can eat, I'm a snake. My bitch from Louisiana and she Creole with stick in hand. Hopping out like she clear. We ain't missing, ain't no shots at the feet. The out of time, got them thinking it's zero. Sticks be as long as a cord extender. You get blown like a cartridge Nintendo. Fuck nigga, ain't you all like you nothing. That's because you be playing the middle. I got an issue with the streets, it's breeding snitches. That's why I'm a family guy like Peter Griffin. Heard about Western Road, think I need a Smith. And issue time with his close, I think he a blister. Matters with the clips, I'm pushing T in my sack. You want the smoke, and you'll get your T at your whack. Alphabet sticks, let the T in the map. Bitch, I'm hotter than few, that's gonna leak out the jet. I'm cooking up dog food. She play with the dick with the tossers. I'm smoking that leaf from Toronto. They watching that whisk like a car show. You look like you want to get shit off your chest. I thought so. I'm back in this game now. You sit at the end of the bench. I thought so.